Adjournment request, if any, from item number 1 to 7.
May I please, Lordship, this item number 1, this appeal arises from the industrial dispute heard from the labor code. I am supposed to address the maintainability. And the similar two other matter are posted on 22nd of this current month. I am trying to post the matter on 22nd.
22nd.
Lordship.
From item number 8 to 14.
May I please, your Lordship? Lordship, I beg to mention item number 10, 11, and 12.
8 to 14.
8 to 14.
8 to 14.
8 to 14.
Yet to be admitted.
Lordship, in this matter, the youngest counsel is from Delhi, and he was not aware that the matter has been listed today
Why is not aware?
because it has been listed before one day only. And he was not
Is
aware.
the pregnancy here?
Lordship, kindly adjourn the matter for the day and list it on 16 December.
What about this notices?
Notice has been
Not being issued this freshman.
in all cases, Lordship, notice has been issued and notice has been issued in all the cases. And they have appeared, Lordship.
Question of law is also framed.
No, Lordship, yet to be admitted.
In fact, without issuance of notice, they appeared on themselves.
Yes, Lord. No, notice issued in all the cases, Lord. Because initially there was a delay of 4 days. So that was found out.
Is altogether different. In fact, noticing
The condemnation of delay, they appeared in all the cases.
condemnation of delay is another thing, but otherwise the notice of the appeal, there is no question of issuance of simply notice without framing the question of law. When?
December 16, Lordship. On this Lordship.
Up to 14. Up to 14. Could you go back? 14 minutes.
It's
14 order.
yes,
Adjournment request from item number 15 to 29.
May I please, Your Lordship? I beg to mention item number 23, Your Lordship. Here, Your Lordship, I would like to withdraw the writ appeal with a liberty to file a fresh one because, Your Lordship, this matter pertains to, Your Lordship, compensation and appointment, Your Lordship. And, Your Lordship, writ appeal has been filed before that OM, Your Lordship. That the OM, that it is 18 September 2024, the review of the compensation appointment, Your Lordship, came into effect before that the writ appeal has been preferred, Your Lordship. So I would like to bring all this record, Your Lordship.
way of the state government.
OM of the state government, after Devabata Tiwari's case, Your Lordship.
How it will help you? They have made a policy that we are not going to consider any appointment.
Lordship, it give me an opportunity, your lordship, with due respect, your lordship, so that I can challenge the OM also, your lordship. Because the writ appeal has been preferred, your lordship, before the
But
OM has.
your writ appeal, your writ appeal was not dismissed while considering this OA,
Your lordship,
this OM,
lordship.
that was not dismissed. They've simply, the Ranit Singhal judges said, since the time has passed and pursuant to the Devdutt Tiwari judgment.
Devdutt Tiwari judgment, your lordship. So, lordship, I would like to drag that, challenge that OM also, your lordship, in the writ
So
appeal.
how can you challenge into that in this appeal, man? You can file an independent, whatever you want to, proceedings, if you want to challenge this OM. How can you challenge this in this writ appeal?
Because, your lordship, the Devdutt Tiwari case was, lordship, regarding delayed delusion of immediacy, and so that OM will.
You can withdraw it with liberty to challenge this OM. We don't have any.
I would feel liberty to challenge this OM, your lordship.
On instructions as submitted, if you want to withdraw this writ appeal, I will seek liberty to avail appropriate remedy. Against the OM number field mentioned before. OM number field. Dismiss with liberty as paid for.
Much obliged.
May I please indulge? With due consent from my counterpart, my lord, I'd like to mention item number 25, my lord. And my lord, the question of maintainability, my lord. So,
22nd of.
Second of-
Fix the matter. 22nd November.
my lord.
Yes.
Lordship,
Adjourn-
we have prepared the affidavit and send it to the official liquidator for vetting.
We'll
We
be
need
hearing
4
on
weeks time.
22nd of November.
22nd. Adjournment request from item number 30 to 40.
With the concept of the other side, I beg to mention item number 35 and 40 minutes.
Yeah.
I pray 10 days adjournment.
35 and
40.
40.
Obliged.
35 and 30.
May I please, your lordship? Lordship, I beg to mention item number 39, lordship.
Yeah,
Lordship, with the consent of the other side, kindly adjourn the matter for the.
22nd. 22nd of November, we will fix similar matters
Lordship,
regarding maintainability of the writ appeal.
lordship. Bless.
May I please, Your Honor? With consent of the other side, my lord, I beg to mention item number 38. I prefer little accommodation, my lord. May I pray for fix the matter on 25th, my lord? The hearing matter.
Lordship, there is an urgency from our side. Lordship, I am appearing for respondent number 10. Lordship, the date may be fixed, Lordship.
25th.
Much obliged, Lordship.
Any other request?
Petition has been filed on 4th, Malak. Let it be on the listed on 18th, Malak. For admission, Malak. Hello.
Daily list for orders item 2 and 3.
May it please, Your Lordship.
Lordship, but five has not been submitted now. Await return of notice of respondent number five for 3 more weeks. Who is appearing in three? You are appearing in this item number three, notices have not been issued.
He will take precedence. Item number 3 appear করছিলাম তো ওইখানে number 5 বলে notice কিন্তু আমি তো appear করেছি এটা কারণ কেন appear করেছি পাইছি কি number notice করেছে তো কিন্তু পাইছে না
Okay. Await return of notice of respondent number five for 3 more weeks.
Item 4.
The respondent number 2, notices have not been served.
yes
Await.
last order
Okay, investigate tribunal. Yeah. 22nd.
by 22nd my lord
Then fix the matters. They have already fixed this.
Right.
Matters some matter. 23.
obliged man
Item 5.
may I please your lordship my lord in this matter I think my lord he is appearing for respondent number 10
for respondent number 10.
yes my
Who
lord
is appearing for respondent number 9?
9 is not contesting party in the writ petition also they are formal party.
Nine is the L2 bidder, but probably he won't come. I am for the department.
He is getting the work now. Respondent number 10
Respondent number 1, who is appearing for respondent 1, 2, 3, 4, 5, 6 or
I am appearing.
6, 7 and 8 up to? Up
My
to
lord.
8?
8. Yes, well.
And you are appearing for 10.
Yes.
Respondent number 9 is not contesting party.
yes my lord.
Of course, I cannot say what the, yes, in the
He is not
petition.
contesting but he is not getting the work man.
Okay. Mr. So-and-so put in appearance on behalf of the respondent number 1 to 8. Mr. So-and-so appearing on behalf of the respondent number 10. It is submitted by the counsel for the appellant that the respondent number 9 is not contesting the matter and therefore service of notice upon him be waived for the time being.
But one thing is that my lord, it was disposed on the motion stage, no? Huh? Motion stage earlier.
Yeah, motion stage B.
Yes, my lord.
The counsel for the appellant has submitted that the respondent number 9 is not going to be affected adversely
Yes, my lord.
by any order passed in this writ. Therefore, the service of notice upon the respondent number 9 be waived for the time being.
Yes, my lord.
In view of the submission made by the counsel for the appellant, in service of notice on the respondent number 9 is waived for the time being at the risk of the appellant.
Yes, sir.
List for admission when
I need a convenient manner.
Can be, my lord. Can be, my lord. Next week, my lord. Can it be,
any date you just
20.
yes, my lord.
20.
Can it be, my lord?
you suggest that court master.
Oh, yes, sir.
Yes, yes.
Yes, my master bless.
Item 6.
Lordship, service report may be awaited, Lordship.
Service is complete.
No, Lordship.
Lauzima court order received in respect of the respondent has been completed. As per the report from the Lauzima court, the service of notice upon the sole respondent is complete. This complete, however, none is appearing on behalf of the sole respondent. This matter for admission after 2 weeks.
Item 7.
Lordship, in the delay condonation petition, Lordship, notice was sent on 17/9, but 6/11 office notes stated that neither ID card nor answer notice returned back, Lordship. Delay up to 24 days.
Await return of notice issued to the respondent for 4 more weeks.
Obliged, Lordship.
For admission, item 15.
Minutes, same issue has been agitated, before your lordships, by PL number 62. Same issue, madam.
My lord, in this,
Rectification
in
notice.
this case, we are on a larger campus. My lord, let me submit first. My lord, our issue is that the Darbhanga Reserve, which was a reserve, was denotified. We are, along with that, we know we have given the order. We have brought in the larger issue. Now a railway is being proposed through the reserve forest, and where the Deepor Bill matter is already connected because it forms the entire ecosystem. It's a symbiotic relation. Our grievance is that once the railway comes in, the non-forest activities will start and it will lead to the complete destruction of the reserve because it's a reserve for 100 years. Now they propose to make it into a wildlife sanctuary without the procedural requirements. So at this stage, notice may go. Because ours is on a larger, I have gone through the petition filed by my learned friend, Mr. Rajkumar. Ours is on the larger issue because we want to connect it with the Deepor Bill. Because it forms an ecosystem, integrated ecosystem. Because only we want the precautionary principle to be complied.
Railway कागज पता है, railway का, railway पता है।
But already a line is there, which has caused a lot of problems for the elephants have died. Now they propose to make a railway line, possibly they want to divert the goods train so that it comes out in near basically Jorabat.
From the
And
same,
from there it will go to Tetelia and
But-
Jagiro.
On the same alignment.
same alignment or
Proposed because now what has happened, the people,
Already one railway line is already there.
yes, they are going for the second.
My lord, it can't be the same alignment because the area which my learned senior pointed out, my lord, these are two different areas, going two different ways, my lord. One goes to Lower Assam, one goes to Upper Assam, my lord. And Jura, but it's impossible to have a railway track. It goes to Narangi that side, my lord.
my lord, our
My lord,
information
it's
is that
only no
we have already
given
given land for the first railway where there were a lot of controversy. Now the marking has started and the indent we have also applied for the RTI. My lord, here I want to say that now the court's position, the judicial system, the judicial entire concept of change in environment from the 90s till the 2000, the issue was development. Now it is sustainable development with more emphasis on environment. And there's a new concept of environmental rule of law because there's so much destruction and aberrations by the authorities. And we want the precautionary principle to be applied now.
Notification. Notifications are representation. Forest wildlife sanctuary commission. Then. Wildlife sanctuary commission. Forest reserve commission. Declared function.
But where is your prayer regarding this railway line? Nothing.
No, we have said, Malad, we have, Malad, your lordship will come to 118. Malad, the courts will be doing a merit review and a proportionality review
Sir,
now.
where is the
Malad, your lordship will find on the last occasion,
prayer?
an objection was, yes, Malad, the prayer is, Malad, we are not seeking an interim order at this stage. We want that the notice is made.
That's another thing.
Malad, we have said,
Interim order, even though it-
yes, Malad, because once the railway comes in, the non-forest activity starts. So lordship, the prayer is, we have sought for.
Prayer, you have said that this withdrawal of notification is bad, it should be cancelled. That is
Yes,
what
but
the-
earlier, Malad, lordship may be pleased to grant adequate interim relief, protecting by directing the respondents not to indulge in any non-forest activity in an area of the wildlife, Garbhanga Wildlife Sanctuary, which was sought to be declared as wildlife.
Self-sufficient in
No,
that, you
yes,
can also-
but, Malad, your lordship will see that in the earlier writ petition, objections were raised by the forest on the ground that we never represented. This is the case, the villagers of the entire, your lordship will come at page 118. The villagers have objected to the railway authorities that you cannot go for a survey because we have already given our land to the earlier railway. Your lordship will come to page 118.
Here, let us file the reply.
Yes, yes, Malad, I'm not seeking any interim order.
The way their things are projecting, my lord, that we will dismantle our cars also, my lord, we'll start walking.
Malad, the way the respondent government always objects,
Oh, look.
your lordship has fixed it on
Sir, along with that 62,
It'll come after 3 weeks.
3 weeks. Obliged.
along with that,
Item 16.
Sir.
another bank. Circle in the town.
My lord,
Item 17.
my lord, interim order may be required, my lord, since there is the.
Interim order is, we have made an exception, how can we pass an interim order? Sir?
My lord. Okay.
Before my learned senior starts, I must point out one thing. The first petitioner who has not joined in this writ appeal has filed a writ appeal before the Itanagar bench. That is coming up on next Tuesday.
Another appeal,
Yes,
identical appeal.
yes. First petitioner. First petitioner.
He has filed an appeal separately.
Separate.
And my prayer will be lordship may issue notice and fix it along with them.
Along with them at Itanagar.
Along with the other, yes, ma'am, yes, ma'am. Yeah, yeah, yeah.
You are appearing for,
5 to 24, madam.
and 125, 124, 124. Sure, this. Mr. Going to put in appearance on behalf of the respondent number 4. 124. Mr. So-and-so is appearing on behalf of the respondent number 5. 24.
24, madam.
Now, sir. So, hence, no need to issue formal notices to the respondents. It is informed that an writ appeal against the improved order is already pending consideration before the usual bench of this court.
Itanagar bench.
Itanagar bench of this court.
Read appeal number 28, madam. 28.
That is writ appeal number 28/2024. Therefore, this writ appeal may also be listed along with the above referred appeal at Itanagar permanent bench. In view of the request made by the counsel for the parties, this writ appeal along with writ appeal number so and so at Itanagar permanent bench.
Oh, right.
Item 18,
May it please your lordship. Lordship, this is against the judgment of the learned Honorable Judge Lordship of 22/4/2024 Lordship. Our ground is that when there was a uh, pending case was there, Lordship, for withholding of one increment for a period of 1 year. That is why, Lordship, we have calculated it after that, the grant of ACP's Lordship. But
Sir, 99. Back to it, 2001 November. Then they rectified it to 117. But the price it is to 99 so much a year. It is delayed 2 years, 3 months, 17 days for delivery. So what delay happen? Second day to be, third day to be, 40 होता है. So इसको जो 40 13 में मिलना चाहिए तो 4 उतना ही. Yes. $99 2000 में उसका रेट पता लगा. वो थोड़ा पता लगा. तो उसको वही 2000 वो explanation नहीं दे रहा.
It appears that this order is not liable to be interfered. Once this, whatever the departmental proceedings were over in 2000, he was supposed to get the ACP benefit from 99. Why you have, what is the explanation for granting in from this 2001?
Lordship, in the judgment, we have already stated, Lordship, page 9, page 20, Lordship.
20 of the judgment?
Page 20 of the appeal, Lordship, page 4 of the judgment, the ground that was taken by the, in the affidavit, Lordship.
No, the movie, no page number.
No, अपना ये directly लगा है इसे calculation की A, B, C, D से कोई दिक्कत. Page number 3.
Ground.
Ground, just. Page number 3.
No, 1,2000. It's been moved to 30. 30. 1 minute. You can move your 30. The new year.
Having heard the non-counsel for the parties admits no need to issue formal notice as part respondent is represented All the respondents?
One
Only
respondent.
one respondent. Respondent is in the concept. This
But-
for the hearing in the month of February.
IA is also there, Lordship, for
Today. Publish.
Item 19.
कोई मुश्किल आते ना
Lord,
Yes.
yes, my lord, we kindly have that compilation which you have given. These are all part of the records.
Yes.
Now, page 5 is the letter of award, my lord, acceptance rather. Now, going by the, my lord, this award letter, providing catering and other services in BGR Guwahati Guest House and Office Complex at Joyanagar 6 Mile, Guwahati. So, my lord, all that they have to do is to provide the catering service. Then my lord will kindly come to page number 8.
Yes.
Now, before my lord, the actual execution of the contract, there was a kick-off meeting held on 25/4/23. Now, kindly see, my lord, what were the discussions which took place. Site will be handed over on 1/5/2023, which was agreed by the contractor as the great petitioner. Then pre-site organogram.
Need a clarification. You are appearing for whom?
I'm appearing for the BRPL, Indian Oil Corporation, Bongaigaon Refinery, who has awarded the contract.
You have not challenged this order?
My lord,
Due order?
as of date, till date, we have not. But we contested the proceeding before the learned single judge.
But then if you are not challenging that order. Yeah, this IUCL is not challenging that order. Whereby these no relief was granted to the existing workers. So you have accepted that judgment or what?
Till date, my lord, we have not preferred any appeal.
Then let him convince the court
Yes, sir.
that where is the term in the contract, where is the condition in the contract which the contractor was bound to keep those persons in
Yes.
service, and where is that?
My lord will kindly
So
come to
the-
page 147.
That was the question the
No, no,
on the
correct,
last
correct.
occasion.
Now, whether the contractor had the obligation to continue the contract with the existing labor contract. Page 147.
147.
Yes. And the operative is at 147, my lord, the special conditions of contract. It starts,
Yes.
the operative portion is at 158.
Yes.
Contract labor wages and benefits. A memorandum of settlement has been signed on revision of wages and other benefits for the contract labor engaged by contractors in the jobs awarded by BZR. This MOS is valid till 31/12/24. So this is a part of the contract, my lord. And kindly come to me, lord, 1.3 at page 148. My lord will kindly come to page 140.
Memorandum of settlement.
Yes. Yes. Those are there, my lord. Now,
Memorandum of settlement has
Yes.
been signed and revision of wages benefit so and so.
yes.
Where is that memorandum?
Yes, yes. My lord, first, my lord will kindly come to page 252.
252.
One second, one second. No, I'm sorry, my lord.
Page 84.
In the compilation, it is there, my lord.
Yes.
Compilation, page 29.
29.
Yes. If your lordship would kindly come to page 30, terms of settlement number 2. The terms of this settlement will be effective from 1/12/11 and will be valid for 4 years till 30/11/2015. Then, my lord, page 34. Serially, I'm coming, my lord. If your lordship would straight away come to page 35. This settlement will be serial number 2. This settlement will be effective from 1st of April 2016 and continue to remain in force till 31/12/19. Then at page 40, the one which is currently holding the field, the relevant portion is at 42. The settlement will be effective from 1st of January 21 and will continue to remain in force till 31/12/24.
Fine.
So these are the memorandum of settlement, Miller.
It's last time also we have point
Yes.
out, where is that condition that the contractor is obliged to keep those employees who are already working with the earlier contractor?
So, my lord, in the kickoff meeting, everything was explained to the contractor. He started work from 1st of May 2023. He started executing.
The deliberations of kickoff meeting,
Yes.
where is that?
My lord will kindly come to page 8, my lord, of that compilation.
8.
Yes. Serial number 3, my lord. Site organogram to be submitted showing details of supervisory and other manpower deputation for execution of the work by 34/23, processing of labor formalities by 15/5/23, mobilization of resources and starting of work execution at site by 1/5/23. After knowing everything, my lord, he started. Then he has issued all this cash memo.
Sir, it's point out this specific that he has to keep these persons in service or engage, is obliged to engage these persons.
No, my lord, he is relying on a particular clause in the general conditions of contract. Let us see, which Lanesh Singhal Judge has also accepted that, my lord.
But can we see
Yes,
letter of acceptance? Letter of acceptance,
yes.
this clause 7 says, terms and all terms and conditions shall be governed by the
GM.
GM contract. That's all. Where is that, sir? You just point
Yes.
out that he was obliged to do that. It may be between, on the last occasion also, we have asked this question and it's, you referred about a settlement.
No, the settlements were not on record, that's why.
He said, I am not the member of that contractor association.
No, my lord, it's not a question. No, please have a look at the settlement, memorandum settlement once, my lord.
Yes.
Please come to the last one, which starts at page
42.
Page 42, yes. Contract workers represented by BZR United Workers Coordination Committee, henafter referred to as so-and-so, a consortium of BRPL Casual Workers Union, Construction Labor Union, Construction of Casual Workers, BRPL Bus and Taxi Karmi Union, BRPL Canteen Staff Union, and Owner and Lower Assam Technical Workers Union. So these are it's a consortium of all the labor unions, my lord. And going by the, my lord, spirit of section 18,
Keep bringing something. With particular conditions. After one time, in the division of pay will be applicable from the date of signing. We need to. The Georgia and the categorical statement is one pipe cover, one pipe. The petition to all requisites that she hand over site on so and so. However, it transferred that the purpose of the tenant refused to pay the kitchen website, as a result, only 1% marketing manager of the petitioner could be placed, and even he could not operate effectively. Without any data. So they say, they remember that he had exactly needs and make himself. Or refuse to leave the site and alleging that support from officers of the responding. And so, category B places design, it is only one man deployed, however, petitioner could not continue and that's low reply was then he has looked twice. Okay, physical construction, the petitioner cannot be permitted to engage another set of contracts. But the cost of existing workers who are working for the not 18 to 20.
My lord, the petitioner, I do not find from the memo of appeal, this is the clause which the petitioner side is relying, my lord. Does it throw any light? Please have a look, my lord. 2.2, contractor scope. The contractor shall at his cost engage adequate number of workforce of various categories, that is 22, as per details given below for carryout. So all that is specified in the contract is that he will have to engage 22 numbers. Those are already employed. They're working for the last 18 years.
That is up to the contractor. He engage those workers. He may outsource somewhere from somewhere else. He may bring those employees from Guwahati or anywhere else. It is only.
So, my lord, lordship will
Sir, what is troubling us until and unless there is a specific condition in the contract, we can't force.
But my lord, at the same time, there is no a clause in the GEM or the contract, all documents forming the contract, my lord, that he can engage his own labor. That is also not there.
Is there, sir? Shall at his cost engage.
At his cost, he has to bear the cost. That is why the settlements, my lord.
That gives leverage.
Anyway, my lord, this is our submission. I leave it to your lord.
You are trying to protect these contractors and file an appeal. That you are not doing.
In that case, my lord, let us revert back to the authority, my lord. Let the matter be called after a week, my lord. We'll see, my lord, if we file it.
2 weeks.
My lord. Deeply.
Item 20.
Yes.
Wait, with the lordship. Lordship, in this writ petition, lordship, my limited prayer is lordship.
Clear. In the protective. Ask. 124, 122. Number on 110 for having witness, if any by the applicant against here with petition file हुआ है मतलब प्रत्येक लेकिन यहाँ पे कोई अगर मैं नहीं है कि 1 एक तारीख के बाद नहीं किया खुद admit that applications are done well, would have very well prepared an appeal before this one. So how do we not file it? As to first, 25% of the, in the case of one bank has abstained from disclosing the appeal to make payment in that again and even more of it. Is in a match can just that's one of the alternative but the whole just negotiation action. But if we can
Now, Lordship, my limited prayer is, Lordship, I may be protected only till the time this case is disposed of, nothing else, Lordship.
Which case is this for?
The essay, Lordship.
We can play before the DRT.
No, Lordship, I have made a prayer, Lordship, and that order, Lordship, has already proposed in page number 124.
The matter is fixed tomorrow, Lordship, before the learned debts recovery tribunal.
No, Lordship, what my submission is.
They
Lordship,
filed similar application before the learned debts recovery tribunal. My lord was pleased in WPC number 2114.
No, madam, let me submit, Lordship, let me submit and then, but my only thing is, Lordship, I understand, Lordship, I have approached this court before. And after the delay was there, delay has been condoned, and I was directed to approach the DRT. And then I approached the DRT, I have filed an IA, Lordship. In that I have prayed or limited prayer that since I have filed an application under section 17, alleging challenging the 13.2 and 13.4 of the Surface Act. Now, section 14 is the outcome of section 13.2 and 13.4, Lordship. Now, at this stage, when I am contesting the suit, if they take possession of the property by throwing me out, what remains, Lordship? There's nothing remains, Lordship. I am not trying to say that I have nothing to pay. I have to pay to the bank. I'm not saying that, Lordship. The only thing is that until and unless if I'm protected, there is no point in filing an IA, Lordship, under section 17, Lordship.
Make the submission before the DRT.
No, Lordship, I have submitted, Lordship.
Then what happened?
This order has been passed.
So DRT has rejected your prayer.
Lordship, yes, Lordship, because when I had
Yes, where is that order that no, will not pass any interim order?
no, Lordship, as per my limited understanding, Lordship, when there is an interim application and there is an
This
ad
order
interim
was
prayer,
passed. When this order was passed,
Lordship, it was passed on 23/9,
and when you approached this court
Lordship, on 30/10, Lordship.
for a month,
No, Lordship, because that time that the holidays were there, Lordship. Holidays were there, Lordship. No, Lordship may kindly appreciate this, Lordship, because what is happening, the circle officer is trying to evict me even today.
file an appeal before the appellate tribunal.
No, Lordship, that will be very, it will not be efficacious for me, Lordship. And Lordship,
That is what.
no, my lord may kindly protect my interest, Lordship, at least till this essay is there, Lordship.
Make this prayer before the DRT.
No, Lordship, that I cannot because I have already applied. Lordship may
They
kindly see.
passed an order. They have not rejected your prayer.
No, Lordship may kindly see page number 1051, Lordship.
Read.
Now, that is my application, Lordship. And my prayer portion, Lordship, would find in page number 119. In 119, Lordship, there is a prayer for ad interim relief, Lordship.
Fine.
I have moved this application,
Now
Lordship.
read order 23/9/2024. 124.
Yes, Lordship.
Yeah.
The matter is taken up as per previous order. Learned counsel has appeared for the applicant. Learned counsel, Mr. K.K. Nandi, has appeared for the respondent bank and filed a written objection on the essay. Taken on record, copy of the same has been received by the learned counsel for the applicant. It is observed that the learned counsel for the applicant has filed an IA number so and so, that this application, Lordship, with a prayer for stay of the order passed by a subdivisional magistrate Kamrup by way of authorized person is appointed to oversee the law and order during taking physical possession of the mortgage property of the applicant along with the service copy taken on record. IA number 604 for urgent listing is disposed of. fix the matter on 1/10/2024 for filing reply, if any, by the applicant against the written objection, if any, against IN number 306 of 2014 and hearing.
So where
No,
the
Lordship.
has refused to grant you ad interim?
No, Lordship, Lordship, as per the civil procedure code, Lordship, if an injunction ad interim prayer is rejected, that is not given, then that amounts to rejection of an interim prayer, Lordship. No, Lordship, kindly see, under Order 41 Rule 39 Rule 2, Lordship, if an application, I have filed an application with an interim prayer, Lordship, if that is
application
rejected.
is still pending, sir. No such order has been passed. Simply, they said, if you want to file any counter to the objection of them, file it.
No, my lord,
What happened on 1/10/2020?
my lord, may kindly
What
understand my
happened on
situation. If today.
What happened on 1/10/2024?
They have filed
They-
another application.
I have
They
filed
have
an
filed
application
another application
Another application for?
for
cross-examination,
cross-examination.
Lordship.
And
For
both the
cross-examination
matters
of
are,
the,
they are filing, your worship, this is a matter of 2019. The loan was classified as NPA way back on 2019. We have filed original application. That was decreed in our favor. Then they have filed review application. That was dismissed. And today we are in 2024. We have initiated SURFACE. They have filed 3 writ applications before this honorable court.
Still is saying that, yes, I have to pay.
And they are saying I am to pay, and they are not paying since 2019.
no, Lordship, I am paying,
The
Lordship.
loan
It
is
is not that I
classified
am
as
not
NPA
paying.
in 2019. And they are saying that in every application, we will pay the legible amount, and they are not paying. That is the conduct.
No, Lordship, may kindly see 102, page number 102, Lordship. This is the amount that they have given me. This is the amount has to be paid. From where? From which? What is the calculation? Nothing. Now, how can
We have submitted before the recovery officer. They are very well present before the recovery.
Now, what- Lordship, I don't want to argue on merits, Lordship. I don't want to argue on merits, Lordship. All I want is some efficacious
No,
remedy.
The matter is.
Only
fixed
thing is
before
that,
our
Lordship,
before the
only thing is that, Lordship, till
presiding
the
officer.
disposal of the essay, Lordship, I may be protected. That is my only thing under section 14. Only thing is that till section 14, because, Lordship, if 13.2 and 13.4 is 14 is an outcome of 13.2 and 13.4, Lordship. I have challenged that, Lordship. And in this case, when an interim order is rejected on the first day, it amounts to rejection of ad interim prayer, Lordship.
Look here. This petition is filed by the petitioner being agreed with the order dated 23/9/2024 passed by the DRT in essay number 78 of 2024. During the pendency of the essay number 78 of 2024, an application is made on behalf of the petitioner before the DRT with a prayer to pass an ad interim stay in its favor, which may result in restraining the respondent authorities to take recourse of the procedure laid down under the Securitization Act. And so on. The DRT, done a DRT, wide order dated 23/9/2024, has fixed the matter on 1/10/2024 while granting opportunity to the petitioner to file a reply to the written objection to the prayer of the ad interim stay filed by the respondent bank. Then the counsel for the petitioner has submitted that by passing the order dated 23/9/2024, the DRT has virtually rejected the prayer of the petitioner to pass an ad interim stay order. Stop. Having heard the learned counsel for the petitioner and after going through the improved order dated 23/9/2024, we don't find that, we are not, we are of the view that the DRT has not rejected the prayer of the petitioner for passing an ad interim stay order. And otherwise also, if the petitioner is agreed by the order dated 23/9/2024, passed by the DRT, can very well file an appeal before the appellate tribunal under section 18 of the Securitization Act. In view of the above, we don't find any merit in this petition, the same is therefore dismissed.
Obliged to keep.
Item 21.
Issue of this.
Item 22.
May it please your lordship, in terms of order dated 8/11, your lordship, I was supposed to file an affidavit to bring on record the rules. I need some further time. Next witness,
Your lordship, I have some objection. Your lordship, I have some objection.
Yeah.
I have some objection to their adjournment, your lordship. Because this is the appellate stage and this is 2024. The original case of is 2021. From 2021 till now, at the appellate stage, they are continuously seeking adjournment, your lordship. That conduct can kindly be taken into consideration.
So either you provide the rules.
Your lordship, the rules I have only shown you the Supreme Court judgment. Where the rules have been,
It is neither here nor there, ma'am.
your lordship, I was providing and I can provide it again. The rules have been discussed properly in this judgment.
Cannot be considered to be valid. I'm the same is supported, but तुम लोग का सर वो रूल में वो है वो देना चाहिए।
They are the authority, your lordship.
next witness, your lordship, positively.
When you are going to place on record those rules.
Next witness, the matter may be fixed, your lordship, coming witness date on 18th, 20th. Deeply obliged.
Item 24.
मेरे पास अवेयर नहीं है।
May it please your lordship. In this matter, I am appearing as a legal aid counsel.
As a legal aid,
Legal aid counsel.
simply because the dead body arrived, in some, there is some discrepancy in mentioning the time. CBI.
Not quite for that, my lord. This would have in two parts. So far as the custodial debt is concerned, that part is not disputed. The only thing is that it might be a homicidal death, it might be a suicidal death. Now, so far as
As per the, this, postmortem report, that is.
the postmortem report, although we had indicated that so far as the inquest report is concerned, it says that the body is lying on the bench. I may invite your lordship's attention to that.
Inquiry lecture coming with the submit was petition liखना है. The same by the by the petition did not challenge such acceptance of the bank. It took 14th item. The inquiry करके पुलिस ने गलत किया अभी उसके बाद 2 साल बाद में इंसिडेंट तो आगे का 21 का है.
Yes,
My lord,
I have to answer many questions.
absolutely, my lord.
In 2022, the court has accepted the final report.
Absolutely.
We have not challenged that.
We have not
And
challenged.
now again, 2 years after you saying that CBI inquiry, what
Well,
evidence now is left?
My lordship, as I stated earlier, if I would have been appearing as a counsel on the private side, then things would have been different. It came to me as a legal aid panel, so I'm addressing your lordship's questions on that
But
pinpointed.
If you
But
are,
may I-
even
may I-
though if you are appearing as a legal
no.
aid, you are supposed to satisfy us regarding the
Absolutely.
maintainability
No, no.
of the petition.
Correct, my lord. If not, please, no,
Yes, sir.
my lord, I would invite my lord's attention to a judgment we had given a.
Even though any
Statement.
person
Correct, my lord.
approaching this court by legal
There
aid
is a
or
judge-
whatever it may be, how it make
But
a
I'll
difference?
address your lordship on that. Firstly, the name of the person who had died is
To
wrong.
answer this question, what happened to that when the final report has already
That
been
was-
accepted
was
by the
accept-
court?
Correct. That was
Again,
not challenged.
whether this court has jurisdiction to open that.
That judgment is
investigation.
there. I'm just bringing that judgment, my lord. In cases after final report is submitted, lordships have the jurisdiction to reopen
Submitted
it.
is altogether different, accepted.
It has to be accepted. They accepted it.
It has to be
Correct.
accepted. What do you mean it has to
No,
be
no, no.
accepted?
They accepted at that
There is
point of time.
opportunity is always granted to the
Correct. My lord,
complainant side to raise
correct.
an action regarding that.
Narazi petition could have been filed. They did not file. No, what I am on is that if I'm able to convince your lordship, persuade to that effect, that things have been wrong. So far as the medical examination is concerned, gentleman who had accosted that person, he was not even a witness therein. The doctor was not even a witness therein. None of the witnesses were there before at the stage, my lord. And my lord, I'm referring to 2020-16 SCC 777. We have prayed for an investigation, de novo, as also for compensation.
Custodial death, if you are then, when you approach the authority is concerned, custodial death already, I think so some guidelines are already there.
But that they would have to pay. We are saying that this is a case where it merits 2020-16 SCC 777, right? This is on the fresh de novo investigation or re-investigation, permissibility after submission of closure report. This is on that.
Yeah.
So if I'm able to proceed your lordship to a point that this merits some further probe, maybe. If not, I leave it to your lordship. The name was wrong, the persons were not there, the body was removed.
this. Directly, well, with a prayer to direct Central Bureau of Investigation to conduct independent investigation in connection with the police case number 52 of the 2021 registered under section 342 slash 34J, 304A of the Indian Penal Code. It is also prayed that the respondent authorities may also be directed to pay suitable compensation to the petitioner for the death of son of the petitioner in police custody. Stop. It appears that son of the petitioner was arrested on 14 on 13/3/2021 in connection with a criminal case registered under section 120B and 302 IPC. 302 IPC. Stop. Effects reveals that on 14/3/2021, the son of the petitioner died in police custody. The police custody the police is claiming that police custody. So the claim of the police is that he committed suicide in the washroom toilet.
Latrine they use.
In the toilet of the police station where he was lost. Stop raising doubt about the death of his son, the petitioner has lost death. FIR number 52 of 2021 with the concerned police station. In that FIR, the investigation was concluded by the police and a negative final report and a final closure report was submitted before the court concerned. Full stop is concerned. The court concerned has accepted the said final report on 7/1/2022, against which date, what was the date?
Date is not indicated, in the record. That was submitted on 7/1/22, but accepted.
Submitted on 7/1/2022.
17/1/22.
Huh?
Accepted on 17/1/22.
And accepted on 17/1/22. Stop. And accepted by the concerned court on 17/1/22. The petitioner has not received acceptance of the final closure report by the court and any further, and has straightway filed this petition. After more than 2 years, praying for a relief that the CBI be directed to conduct investigation into the FIR lodged by the petitioner. Full stop. And it concept of the petitioner has placed reliance on the decision rendered by the Honorable Supreme Court in Neetu Kumari Nagaich versus State of Rajasthan and others reported in 2020, 16 SCC 777, and has argued that the Constitutional Court can direct but can issue a direction for fresh investigation by an independent agency. Is submitted that in the present case, also the son of the petitioner died in police custody in doubtful circumstances. And therefore, it is a good case where the direction can be issued to the investigation to conduct, to further, to conduct a de novo investigation into the FIR filed by the petitioner. So, having heard the learned concept of the petitioner and after going through the material available on record, we are of the view that no case for issuing direction to the Central Bureau of Investigation to conduct de novo investigation into the FIR filed by the petitioner is made out. So the Honorable Supreme Court in Neetu Kumari Nagaich, though has observed that in a proper and in a proper case, order for fresh investigation by an independent agency can be considered. However, can be considered, but it is also mentioned that the power may also be exercised if the court comes to the conclusion that the investigation done in a manner that someone escape the clutches of the law. In exceptional circumstances only, the court may, in order to prevent miscarriage of criminal justice, direct de novo investigation. As observed earlier, the petitioner has failed to make out the exceptional case and has also failed to satisfy us that the investigation by the police was done in a manner to help someone escape the clutches of the law. So far as regarding escape the law, hence no such direction for no such direction can be issued with the Central Bureau of Investigation to conduct a de novo investigation in police case, Tinsukia police case number 52/2021. However, this order will not preclude the petitioner from seeking suitable compensation for the death of his son in accordance with law. These observations and permission is just.
Item 26.
In this case, there was a direction to file affidavit, my lord. We have received the instruction, 1 week time may kindly be granted to file affidavit. Affidavit is also ready filed.
Item number, this is 26. 26, you are appearing in item number 26?
Case number 26. Yes, ma'am. 48 no है
Huh?
Yeah, 48.
Yes.
I think 26.
Instruction anything.
Yes. When you are going to file,
Within a week, my lord.
let me consider the teacher now. Appearing for the state pays more time to file. Yes. File, petition. File, counter to the execution. Time paper is after 2 weeks.
Item 27.
Lordship will kindly pass over for the time being, your lordship. Learned senior counsel, Mr. K. N. Chaudhary, he's on legs, your lordship. He's in this matter, your
We have filed an affidavit in this case. Lordship. In very categorical terms, we have said, none of the banks of river, the Dighali Pukhuri tank will be touched. There will be not a single tree will be affected. We have remodified the whole design. And one arm will start from in front of Ravindra Bhavan, the other one from the Lamb Road, which is quite far away from the Dighali Pukhuri. Paragraph 7 is very clearly stated. Lord. This is by the PWD department, Lord. The secretary to the PWD department.
That another affidavit is by him.
They have filed an additional affidavit. Lord.
You have filed today only.
No, we filed day before yesterday. On 11th. Today is 13th. Day before yesterday, we filed it.
We filed an additional affidavit, your lordship.
Additional affidavit for what?
There was certain information we had brought on record, your lordship, regarding an RTI.
And may I read paragraph 7?
It's in late.
Yes, sir.
My lord, As far as Digulipukuri is concerned, perhaps, my lord, they have made their stand clear that now they are not touching. My lord, by filing the additional affidavit, my lord, you have also brought on record. Yes. If your lordship would kindly have the additional affidavit, my lord. It's of record, I said. Oh,
Not on record, Your Lordship.
You,
I apologize.
uh, password. Oh, okay.
Now, just to show my lord how things were done, please come to page 43, my lord.
43, yeah.
Yes, paragraph 3, in respect of Digulipukuri, this is the application which was filed under RTI and the replies were given, subpara 2.
Yes.
How many trees will be cut or uprooted on each bank of historic tank for construction of the flyover? They said 21 number of trees will be impacted, some complete uprooting and some only branches. Then 4, has the authority carried out any impact assessment to safeguard the environmental aspect of the historical location, including impact of felling tree, loss of home, for variety of birds, traffic management, management of anticipated flash flood in the area? Reply, no. Has the authority conducted any public hearing to discuss the pros and cons regarding the project? No. Well, Lord, these are this pre-decisional hearing status. Now, because public has raised hue and cry, my lord, now government has come down. Otherwise, this is how things are being done, my lord. Well, at the end of the day, my lord, they should take some expert's view. So whether in a particular point there is a traffic rotary is required or a flyover is required, Indian Road Congress, my lord, guidelines are there. Now, some political executive cannot take all the decisions, my lord. They may have the best of the intentions, but my lord, the end of the day, the views of the experts are to be taken.
And if they're not taken, therefore they have.
Precisely. So, my lord, in the additional affidavit, another aspect which we have brought out in paragraph 4, my lord, regarding Digulipukuri, that the deponent begs to state.
Yes, it is.
Page 44.
Your additional affidavit is in record.
Yes.
Sorry.
Para 4, my lord, at page 44.
Yes.
That the deponent begs to state that amidst the protests for protection of trees on the bank of Digulipukuri Pond, a parallel demonstration materialized at Bhorolumuk area, as the authority has marked over 70 well-grown and old trees for felling for a proposed flyover connecting the sluice gate on R.K. Chaudhary Road to the new road built along Brahmaputra River on the railway crossing. The said news was published in Times of India titled "Steer Against Tree Felling on Plan to Cut 70 plus more Bhorolumuk IRC citizens," dated 4/11/24, and in Procedural time titled "Bhorolumuk Resident Protest Chopping of Trees for Flyover," dated so and so. The deponent further begs to state that such unregulated felling of tree in the name of flyover project has resulted in felling of around 7,000 trees in Guwahati, as per the media report, and poses a serious threat to the environment, local climate of Guwahati, thereby infringing upon the right to life and healthy environments granted by the Constitution. So, my lord, these are the aspects.
You consider it and you find it for separate, it's only for that Digalpuri. For that purpose, now the stand of the government is clear, will record there.
Yes. And regarding Digulipukuri, sorry, my lord, Bhorolumuk, liberty may be given, my lord, or anyway.
Lordship, what they are projected, that 7,000 trees are cut in Guwahati and about 70. We have to follow a particular procedure. There's a statute and there's a norms that against one tree, we have to plant 10. The news report is one-sided. They have said that 7,000 or 70 trees are cut. But we are planting 1 crore trees in the state. Where is that news?
There are those trees.
And everybody knows, my lord, out of 1
No, Lord.
crore, how many have
No, no,
survived?
the thing is that all across the country, huge infrastructure work, are there not trees being,
We don't want to go into all.
yes, Lordship.
The state of.
Now we are following the sustainable
All of
development.
us, and let's better not to make any comment on. the
Somebody may
all
want to
claims,
score
your
political
tall
points, I have no
claims and
objection.
Everything, every tall claims by the state government, individuals, NGOs and everything is passed.
Lords.
Nobody is really taking care of the. This
If the,
environment
if
and all,
I would
and
like to, I would
including
like
us-
to place one
including
simple
us
question.
also.
Whether the person who is agitating Lordship, whether while building his house, did he cut a tree or not?
That's the reality with everyone.
It's a very, one of the most irrelevant question, my lord.
Yes, this is irrelevant.
Most
When we say it is irrelevant, whatever comes from a learned friend's mouth, it is all relevant.
Sir, this is the reality. and it
We
is
say we
that
have to accept certain
all of
things.
us are part of it.
But
Yes.
I know one thing, my lord,
Even to,
every litigation is not
even
to
to
be
construct
opposed.
a hospital also.
There
we
are
have to cut trees.
litigations
Let us
which
sit down.
are in public interest also. Every litigation is not to be
Better
opposed.
less to say, because everybody is.
Whenever this
including us
opposition
also,
comes, my friend takes these records now.
Okay.
We have to duty
This-
to give the correct
this
facts
case
before the honorable court.
filed By the petitioner essentially raising a grievance that the state agencies have decided to construct two arms. They decided to construct two arms. Payamida Road 390 meters and West Digalpuri Road 250 meters, connecting the under construction elevated corridor / road of GNB road from the RBI office to Ambari, FEI go down in Gunma. It is, it is alleged that on account of construction of above referred two arms, the old trees aged about 100 years or more in and around the Digalipuri pond are required to fell down. Full stop. It is also stated in the petition that thousands of residents of Guwahati who are concerned about the environment are protesting against the action of the respondent of felling the 100 years, felling the trees who are 100 years old or more than that. Would stop. This court by the order dated 4/11/2024 issued notices to the respondent number 1 to 4 to clarify their stand, to clarify its stand. It stopped. In response to the clarified stand, though Mr. Sekia, learned Advocate General, has submitted before this court that the government, that the state government is considering, is seriously considering to change the alignment of the road to avoid felling of the felling of the old trees. Would stop. And affidavit is filed on behalf of the, affidavit is filed on behalf of the state to secretary to the government of Assam Public Works Road Department, Dispur, Guwahati, wherein it is specifically stated that the matter was taken up at highest level and on 5/11/2024, Honorable Chief Minister of Assam has announced about realignment of the proposed flyover without affecting the two sides of Igali Pukri pond and trees standing therein. Full stop. The relevant portion of the affidavit is expected here under this page number 71. This in view of the fact that now the state government has decided to change the alignment of the two arms, which could have resulted into felling of cutting off trees which are 100 years old or more. We are of the view that no further the grievances raised by the petitioner in this PL petition has already been written. Hence, no further order is required to be passed in this petition. Needless to say that if in future, if the petitioner or any other vigilant citizen feels that the state agencies are working, are not protecting the environment, he or she may be free to approach this court by way of appropriate procedures.
The whole paragraph 7 may be quoted, Lordship, because we have stated several events.
In
In the first,
you have said that this agency को आपने किया था, that is at 11. Sir. Once you have engaged the agency and they have conducted a survey and all, that relevant para is there, sir.
yeah, that Haryana party came, Lordship, all these are there. If Lordship is pleased to come to page
Sir, this
5.
deponent states that this is the main crux of the matter.
Change of alignment
No.
and no cutting.
That is one. And the last part, Lordship,
Yes,
just above paragraph 8.
just above,
Just above paragraph 8,
that we have already quoted, sir, this whole,
Lordship.
this
Lord.
deponent from this paragraph, sub-para of this, just above the para number 8, we have quoted.
Lordship.
Isn't it?
Deep level.
Highly obliged, Lordship.
Item 28.
Yes.
Lordship, this selection, the post of revenue shares that were under challenge. Criteria for selection was only merit. But learned single judge has said that length of service has been considered by the authority, that is best. As per circular, merit is the only criteria. And the court has said that I have not placed how merit have to be assessed. Merit, my merit is very good of all 5 years. His is good. And length of service has been considered as a criteria for promotion.
There is that rule or guideline which you are taking.
Lordship. Page 46. There is a circular to the post of revenue solicitors.
Yes.
And last portion, Lordship, page 47.
Yes.
Under subdivision shall be on the basis of assessment of annual confidential report of every eligible candidate and other relevant particulars. Page 47.
47. Yeah. Please, only on the basis of this annual confidential report,
And service particulars.
every eligible candidate, other relevant service records, service
Service
records include, it's a very wide, the seniority, everything has to be considered.
Only relevant service record, not on any other basis such as interview or viva voice. Because
Not on
in the,
any other basis, that the service record include everything.
but assessment of merit, Learned Singh Gupta has held that assessment of merit, not on the basis of the assessment of grading given in the service record for 5 years. Assessment given on the assessment given and every year, my assessment is very good for every 5 years.
Maybe sir, he was senior to you, admittedly he is senior to you.
He is senior to me.
Yeah.
But
Then-
Lordship will kindly see the judgment.
Yeah.
Page 129.
Which
What has
para
been
you-
considered?
Which para you are referring?
Page 129, last paragraph.
Yes,
The employer concerned is the base judge. Criteria required for setting the base man to the job. The criteria adopted by the selection committee examining the number of years of service rendered by the revenue branch. Page 129, last paragraph. Para 25.
as discussed above,
Lordship. Last one.
you read from this start of the para.
As discussed above, no malice has been alleged against any of the members of selection committee. The court concerned with the process of decision making arrived at by the selection committee, which upon careful examination the records have been found to be undertaken keeping the rules and procedure in view. Although the procedure adopted by the selection committee is not reflected in the minutes or in the counter affidavit filed on behalf of the department. However, the same is discernible upon examination of the record, and also the court has accepted the submission made by the Learned Standing Council on the basis of instruction received. The employer concerned is the base judge of criteria required for selecting the base man in the job. The criteria adopted by the selection committee examining the number of years of service rendered by the revenue branch over and above the individual. Grading of the ACR can be accepted to be valid criteria for selection undertaken without looking to the ACR.
Without looking the ACR means.
Look here.
the
Above
number of
the-
service
above the
rendered by
individual-
revenue branch
above
over
the
and above
individual
the
grading.
individual Grading of SDR can be accepted as valid criteria.
Above the individual grading.
So in the, this.
They have- Individual grading has been overlooked totally.
See, where is the criteria for whether that criteria was placed before the learned single judge?
Yes,
Where is that criteria?
Lordship, criteria is merit. I have enclosed my ACR.
No, there is the selection committee has, this, considered only the service years.
Only service year.
No, where is that?
They have not produced anything.
Main page, Lordship. Lordship, I'm appearing for the respond number 1 here, my lord. In this case, my lord, the Assam Ministerial District Establishment Service Rules 1967 is governed, my lord. Now, my lord, rules 6, sub-rule, Lordship, if your Lordship takes up the Assam Services Ministerial Rule, there, my lord, rule 6, subclause 8. Subclause 8(1), my lord. My lord, 8(3), it shows, my lord, the appointing authority shall advertise the vacancies by itself or may instruct the DC concerned to advertise the vacancies, inviting application from suitable persons eligible for appointment in the post of AO, fulfilling the requirement of the post as per clause 1 above. The appointing authority shall obtain, my lord, the annual confidential reports for the last 5 consecutive years. And my lord, this is crucial, and relevant service particulars of the eligible candidates for recruitment to the cadre of AO, and place the annual confidential reports along with the relevant service particulars of the candidates before the selection board with the number of vacancies likely to occur during the year. the selection board shall examine the ACRs and service particulars of the candidates, taking into consideration of the respective merit of the candidate, and prepare a list of the names in order of preference for recruitment to the post. Now, my lord, in this case, the most crucial thing is the advertisement that is at page 42. The advertisement is for the post of revenue Shesada. Now here, my lord, if your lordship sees, just below the 8.3, which I just now read the rule, there, the note is there, it's given the rank and status of AO, that is administrative officer, shall be equal to revenue Shesada. That means the rank and status is equal. However, the job description of AO and revenue Shesada shall be as follows. All revenue matters will be looked after by revenue Shesada, whereas all administrative officer will look after the following subject, that is personal branch, magistrate branch, and planning and development branch. Now, my lord, here, the honorable single bench, my lord, rightfully has given this judgment because of the fact that, lordship, we had, on the last occasion, we had to produce the records in that case, when we had produced the records, original records, where we showed that the respondent number 4 in the writ petition had got more revenue experience than the petitioner over here, my lord, the appellant over here. And my lord, and the honorable court was satisfied. If your lordship sees the judgment, para 5 of the judgment, the honorable court has given full, my lord, has recorded all that, my lord, that they have checked all the records, my lord. So based on the records, so the records will be crucial, my lord. If your lordship allows me, I can trace the record also, my lord. So that will be, that will showcase everything, my lord, that the respondent number 4 had got more revenue experience. So the crucial thing is that the revenue experience of the respondent number 4 was more than the petitioner. So on that basis, plus, my lord, there was another factor which was there. That is, my lord, the respondent number 4 is senior to the petitioner. Respondent number 5 completed 15 years on 28/8/2005, whereas this petitioner has completed 15 years on 4/4/2005.
That will prevail on seniority and merit.
And my lord, the the rule itself speaks for itself. There is that
When merit is a criteria, seniority has no role to play.
Sir, merit is not the sole criteria.
Merit and service particulars.
Service particulars includes
And
length of service, sir.
my service particulars has been reported that it is excellent.
Whatever it may be, length of service is also one of the relevant service record.
My humble submission is, Lordship, when merit is the criteria, seniority has no role to play.
Lordship may also pay the advertisement, second paragraph of the advertisement.
on page 42.
Page 40.
That is for revenue Shesada, my lord, post.
Yeah, what is that?
Page 42.
Page 42.
Second paragraph.
Read.
The candidate must have served at least 15 years in any of the deputy commissioners' establishment in Assam and experience in different branches in general and revenue branch in particular.
Yes.
Lordship, I have made a categorical statement in my petition also that I have more experience than him in the revenue branch, and he has not worked in the revenue branch itself. And reply having given to that effect. In reply also, they have not said anything that he has more experience in revenue branch.
Lordship can kindly come to page 122. That will make it clear. The honorable court has recorded my lord made a chart of the record which we have produced in the last occasion. It is at page 123 to be precise, my lord. Paragraph 17. Paragraph 17, page 123, my lord. There, my lord, insofar as the writ petitioner is concerned, the service rendered under various branches is as under. My lord, kindly see. From the whole thing is given here, the chart. This I had produced last time. So here, my lord, if your lordship sees, he has got experience from 28/8/1990 to 31/12/1990 in accounts branch. That is not a revenue branch. Second comes land reforms branch, 1/1/1991 to 31/3/1991. Then SPPL branch, 1/4/1991 to 31/12/1994. Then confidential A branch, my lord, 195 to 31,395. These are all administrative branches. My lord. Then my lord, land acquisition branch. This is of course revenue branch, land acquisition 1/4/1997 to 36/2004. Then my lord, district magistrate branch 1 July 2007 to 36/2009. That is my lord again administrative and planning and development branch. Then my lord, next is land acquisition branch. This is of course my lord land revenue. My lord 1 July to 36 that is 2009. Then my lord again administration branch 1/7/2009 to 34/2011. Then again personal branch, which is not a my lord revenue branch. That is 1/5/2011 to 31/8/15. Then again, my lord, he has come to land acquisition branch, which is revenue, my lord, 1/9/15 to 30/10/17. Then my lord, again, he's come back to my lord, panchayat and election, my lord, from 1/11/17 till date. Thereafter, if your lordship comes to the next chart, that is my lord of respond number 4, who's the current respond of Yama. Respond number 4 has been my lord at my lord. So my lord, one thing we can note from the petitioner's thing, my lord, he has not got any circle branch experience, my lord. Now we come to the next one, my lord, that is respond number 4 from 19/12/1995 to 15/8/2005. He was in the relief branch, that my lord, land disaster management. Then my lord, personal branch, that is administrative branch from 22/1/97 to 2/1/2001. Then my lord, this is crucial, circle revenue branch. This is total circle work, my lord. This is from 13/3/2000 to 21/2003. Then my lord, excise branch from 14/3/2001 to so and so, my lord, 2001. Then my lord, this is my lord again, next my lord, development block branch default. This is my lord again land revenue. From 4/3/2006 to 1/11/2004. Then next again, my lord, he was in circle revenue from circle revenue, my lord, from 10/4/2008 to 5/1/2002. Then he was in the loan branch. Then from 14/10/2009 to 3/6/2001. Then my lord, sub-registrar's office. That also comes under land revenue, my lord. And last, my lord, he was in the revenue Kanango branch. That is also the land revenue, my lord. So technically, my lord, the respond number 4 has got more experience in revenue.
My submission is, Lordship, I am para 8 of the petition. I have specifically stated that Assam Ministerial Discretion Service Rule has been amended by Gazette notification dated 25/8/1999, whereby cadre of Sirosdar has been notified as a revenue Sirosdar. Qualification to the post has been prescribed as 15 years of service in the Deputy Commissioner establishment and have experience in different branches in general and revenue branch in particular. Selection committee has also prescribed and selection base consists of 4 members and of Government of Assam. General Administrative Department is the chairman, Commissioner and Concerned Division member and DC of the concerned district and member of the Deputy Commissioner, Government of Assam. General Administrative Department is the secretary of the board. Will examine the annual confidential report, other service particulars of eligible person for assessment of merit, and thereafter prepare a list of the name in order of preference for recruitment of post. Thereafter, he shall forward the appointing authority. But in this particular case, the commissioner was not present in the selection meeting. And secondly, I have more experience than him in the revenue branch. And only thing is, he is senior. Only he is senior. That has been considered. So seniority has no role. My submission is, Lordship, seniority has no role to play when merit is the criteria. Seniority will come into play when selection is based on merit, selection, merit, and seniority come merit. Minimum merit, and then seniority. Here, Lordship, the merit is the only criteria. They have to give importance to the annual confidential report. Yes. And I have quoted in paragraph number 15, my ACR. My ACR is very good for page 33. Page 33 of the.
Yes.
Where I have stated that the grading given in the ACR, my ACR is very good everywhere. And his is good for 3 consecutive years. 4 consecutive years. Very good for only 2.
Well, very good. This His name is Umesh. Umesh
Lordship.
Chandra. His name is Umesh.
Umesh, Lordship.
Umesh is also having 1, 2, 3, 4, 5. Very good.
Very good for some period, for the year. But next is good, good, good. My case, very good.
That's all. Close for all.
Obliged.
DP obliged.
Item 29.
Take it a decision forward. Take it a- I have received some instructions in the matter, my lord, they are pursuant to the honorable, the Lanet single judge judgment. But they have already passed the notification on 4th of May, my lord, and they have complied with the order, and I am told that the departmental proceeding is at the final stage, my lord. They are going to issue the order, final order in compliance with the order, the judgment. Lord, as regard the stage of departmental proceeding, Lord, they have indicated, Lord, the written instruction that I'll also get, Lord. They have said that the enquiry report is already there. On the stage of enquiry report is already, it is a part of this writ appeal also, Lord. Lord, from that stage, they will proceed for passing the order. Because the impugned order, which is under challenge in the appeal also, the punishment order he has challenged, that order has been set aside by the learning signature. And the enquiry report is already there. From that stage only, they will proceed further in the matter as per Rule 21. There are Rule 21, Rule 20, 21. Keep that.
Yes,
My lord. My lord, here already they have said that they are complying with the order. They will start from the stage, which stage? So basically, inquiry was over, inquiry report was given, my lord. There is only stage that,
to passing an order.
yes, my lord. Because disciplinary proceeding was initiated before my retirement and it was even concluded before my retirement, and that cannot be deemed after continuation, deemed continuation after my retirement, because penalty was imposed before my retirement, my lord, and that cannot be converted.
Once the penalty is set aside, and the granted single judge has said, "Okay, you continue with the inquiry," then certainly it has to be converted into that inquiry after retirement.
My lord, my humble submission is no, because, my lord, if your lordship ever look at the page, order 21, my lord, sorry, rule 21, my lord.
Yes.
The governor of Assam reserves to himself the right of withholding or withdrawing a pension or any part of it, whether permanently or for a specified period, and the right of ordering the recovery from a pension of the whole or part of any pecuniary loss caused to the government. The governor has reserved the right, my lord. The court cannot exercise that jurisdiction, my lord. My humble submission is there. And number two, my lord, there must be some pecuniary loss. And if your lordship have a look at the charge number 2, my lord, regarding the pecuniary loss, that was not proven itself.
That was not.
And my lord, regarding charge number 1, the appellant was neither the approving authority nor the disbursing authority. Because if your lordship will look at the findings and conclusion of the inquiry officer at page 65, my lord.
Yeah.
The section 4, part 1 of general conditions of contract in clause 1.1 defines the engineer as follows. The engineer is the person named in the contract data or any other competent person appointed by the employer and notified to the contractor to act in replacement of the engineer who is responsible for supervising the execution of the works, administering the contract. Number 2, engineer as per contract data is executive engineer PWD, who is the charge officer. Number 3, as per clause 45.1 of the agreement, the contractor shall submit bank guarantees issued by a commercial bank. To whom, my lord? It was not written. If your lordship allows me, I can submit the relevant portion 45.1, my lord. If your lordship will look at that. अरे बताइए कि जॉब स्टेटमेंट करते यार फर्स्ट पेज पे.
Yes.
The 45.1, my lord. The employer will make the following advance payment to the contractor against provision by the contractor of an unconditional bank guarantee in a form and by commercial bank acceptable to the employer in amounts equal to the advance payment. So it is the employer, it is a safe engineer, my lord, employer. Mobilization advance up to 5% of the contractor price, excluding the contract price, or for routine maintenance, equipment advance up to 90% of the cost of new equipment brought to the site, subject to the maximum of 10% of the contract price, excluding the contract price for routine maintenance. And the letter which was issued by the chief engineer for the equipment advances the letter dated 4/5/2008, which has been relied by the appellant during the inquiry, my lord, it was issued to the superintendent engineer, not to the executive engineer, not to the appellant, my lord. The only role of the appellant was
Well, the inquiry report, the second part, Lordship, see, kindly.
You've seen that. This, it was something that by acceptance of that bank guarantee. Is any cause, loss has been caused to the government?
Well, so far the charge has been charged claimed against the Department of Property Matter. Charge number 1 is proved, 2 is not proved. This is
Who is not proved? Forget it too. What about charge number 1 on account of acceptance? Suppose we admit that yes, he should have verified it that is not a commercial bank and it's only a cooperative society. Why he has done this? But by his act, any loss has been caused to the government or not?
No, going by this report, Malon, they have alleged that without safeguarding the interest of the government and in violation of the guidelines, he has acted, and that is why charges negligence.
From the guidelines, no doubt.
Not.
But any loss?
So far, this from this inquiry report, Malon, it's
why. Again, this person has already suffered.
Well, at this stage, Malon, my humble submission would be Malon. The departmental inquiry ultimately it has to come to an end. Ultimately, it is with them. They are a decision of the matter.
That this inquiry report or charge itself is nothing.
Yes.
This court can very well set aside all the wrong.
Well, the punishment order it was set aside and the departmental proceeding they have already they are going with that now.
File your counter take them to
I'll
being heard the response of the party. Heard response of the issue notice. Going to accept notice on behalf of all the respondents.
Here all the respondents.
There's some time to.
No. Sorry, well, accept fee. Fee is finance department. 1, 2, and 4 I am appearing. Fee is finance.
Finance department.
Well, Lordship may record the name of Mr. B. Burgo. He will.
Mr. So is appearing on behalf of Mr. B. Burwa is appearing on behalf of the finance department. Mr. There's some time to file conflict. Time trade for his practice in the meantime. No. But in the meantime, the respondents are restrained to pass final order in connection with the inquiry, which is that inquiry. Pass any final order in the departmental proceedings initiated against the appellant.
And my lord,
Till next stage.
my lord, in that case, my lord, honorable single judge has stated that if it is not, if the disciplinary proceeding was being continued, then the pension, whole pension should be given, my lord. That was the observation also in the single judgment.
Let them file their reply, consider.
Much obliged. After 3 weeks.
Item 30.
May I please, your lordship? I have received the calculations, lordship.
You have seen the
Calculations, lordship. I shall file affidavit.
As per order dated 24/5/24. No.
You will find the writ after the IA was.
My lord.
When the IA was, that petition has already been disposed of,
My lord.
reiterating the position.
My lord.
Then what more is there?
My lord, because my lord, one I have filed for correction of particular case number, my lord, that was not allowed. Holding that, my lord, since there is a case pending against that.
They have passed orders without considering your, that part of the relief, that areas,
40
Well,
months.
right?
Arrears and salary of 14 months.
14.
40 months.
Which they say you are not applying because of no one.
Yes, my lord, that I have challenged, my lord,
Challenge
and your lordship was pleased to allow the petition.
2193/2015. And the director of the court is saying that whatever is due to him in terms of the BRS notification, pay.
Well,
What is left in this?
Yes, lordship, we have already.
I am, my lord, only for the correction of particular case number.
But when the already relief has already been, whatever relief you are seeking, that has already been granted in another writ petition, where is the question of now again passing that order? Why to keep this pending?
My lord, on the last occasion, they are supposed to give the calculation, what method they have adopted now.
He is seeking for that calculation.
Lordship, kindly have a look, the order date is 24.
4 weeks.
Good. Deeply.
Item 31 to 33.
If your lordship would kindly have a look at order dated, my lord, 6/2/23.
This lateral bench has answered this question.
It has been answered, but there is a requirement of notice.
Yes.
Now, even in case of 18(2), my lord, notice has to be given. Not only that, my lord, there's another aspect in this case. Against the order of the learned single judge, we have filed this writ appeal. Now, my lord, an order was passed on 6/2/23, which your lordships will find in the main PIL so moto 10/18, my lord. That's it, recorded, na? Now, it's a long order. I'll have your lordship's kind attention to para 23 at page 39.
6th of February.
6th of February, yes. 6th of February 23.
Yeah.
It's a long order. If your lordships would kindly come to page 39. 39 it will, no? Para 22, my lord.
Yes.
In view of the above, if any of the petitioners who are illegally occupying the government land are also of the view that they have an independent legal right for allotment of land under the land policy of 2019, such individual persons without any reference to any notice of eviction that may be issued to them under Rule 18 may also make their individual applications to the Deputy Commissioner Kamrup Metro for allotment of land under the land policy. Accordingly, the following directions are issued. The Deputy Commissioner, Kamrup Metro and the respective circle officers, if upon materials on record are of the view that certain persons are illegally encroaching upon government land, individual notices under Rule 18 of Regulation of 86 be issued to them forthwith, and all such individual notices be dealt by passing individual region order. In any such notice, if any of the person takes a stand of having bona fide claim over the land, the same be also decided upon by the Deputy Commissioner based on the materials on record that may be produced by such person. If in respect of such individual person, the Deputy Commissioner arrives that there are no bona fide claim, the appropriate reason order may be passed. On the other hand, if the order in respect of any such person is that the person may have a bona fide claim, the Deputy Commissioner may accordingly pass his own order and subject such person to appropriate provisions of law. If any of the person make any individual application for allotment of land under the land policy of 2019, Deputy Commissioner shall subject such applicant for his appropriate consideration under law and pass a reasoned order, whether in facts and circumstances of the individual, the person concerned has any legal right for allotment of any government land, and accordingly, if the Deputy Commissioner is of the view that given the person is entitled to a reasoned order, be passed. On the other hand, if the Deputy Commissioner has the view that somebody has any kind of entitlement, again, another reasoned order may be passed in respect of such person. So, well, basically, the gist of the order was that individual notices would be issued in case of they want to start any eviction, because earlier, my lord, a general notice was issued. And secondly, if the individual applicants make any application for allotment of land, their cases will. Now, the fact of the matter is, till date, my lord, we have not received any individual notice. So in that view of the matter, can I pray, my lord, these writ appeals can be closed by giving us liberty. If the issuer's notice in this case, we will approach this honorable court. Otherwise, my lord, the matter is pending at that stage.
Lordship, Lordship, this regarding the updated status report in PL Sumoto 10 of 2018, Your Lordship, several affidavits has been filed time and again by the Deputy Commissioner of Kamrup Metro, Your Lordship. On the affidavit dated 30/11/2023, Your Lordship. there a detailed report has already been furnished by the district administration, Your Lordship, whereby it is stated whatever steps has been taken, Your Lordship. And in the meantime, what happened, Your Lordship, under the Guwahati Revenue Circle, Your Lordship, there the encroachers were issued the eviction notices, Your Lordship, and they preferred writ petition before the Honorable Single Bench, Your Lordship. Or in that bunch of cases, Your Lordship, stay order was operating. So that bunch of cases got disposed of on 7th of November, Your Lordship, recently, Your Lordship, whereby the Honorable Single Judge has directed the district administration to give individual hearing and pass speaking orders thereof.
That
So what-
that is already passed.
Yes,
That
Your
order is
Lordship.
already-
Yes, Your Lordship.
But in respect of the appellants, my lord, in these two appeals, no notice has been served upon us, still there. Pursuant after this 6 to 20,
That writ-
maybe somebody, other people.
that writ petition.
No, we are not parties.
Can I submit, Your Lordship? See what has happened, because this writ petitions were going on time and again, the hearing was going on continuing. So what has happened, the entire process got stalled. Also, Your Lordship, in this last affidavit, Your Lordship, which I am mentioning, there it is stated that several people have been issued eviction notices, and there were also this communication, Your Lordship, I have. This is regarding the docking down under Beltola Moza, whereby the allotted land, the land was allotted to Monovikas Kendro, Your Lordship, and this will be allotted in the favor of Rashtriya Adarsha Ved Vidyalaya. So these developments were taking place, Your Lordship. So it is not that the district administration was not doing anything. Time and again, it's just going on, but then the single bench matters were on. That's why no such strict order was passed or no such strict step was taken by the district administration.
টোটেল কিমান আমি আছো দুইটা মিলি এটা এটা কোৱা এডিট কিমান আছিলে অৰবিন্দ হা আৰু এইটোত কেশৱ বৰ্মন বহুত আছে এইটো as volume to do with the party. Huh? Yes.
Lordship, if I
Do you
may
have a
furnish-
copy of Leonard Singleton?
Yes, Your Lordship, I have.
188.
Lordship, may kindly permit page 50, second last page. Page 50 and 51, the directive.
Yeah.
Yes.
May I read? Accordingly, this court therefore disposes of the instant batch of these writ petitions with the following observations and directions. The impugned notices under Rule 18 so issued to the petitioners to vacate shall be construed as notices issued by the Circle Officer, Guwahati Revenue Circle, to show cause why the petitioner should not be evicted by taking recourse to Rule 18 of the settlement rules. The petitioners in the present batch of writ petitions are given the liberty to submit individual replies and substantiating the same with documents and such evidences as deemed proper, thereby showing cause that the petitioners have a bona fide claim of right involved in respect to the land under their occupation, and as such, the recourse to Rule 18 of the settlement rule is not permissible. The liberty given above is to be exercised within 30 days from the date of the instant order. In the said replies, the petitioners herein shall indicate in which writ petition the petitioners were parties. The Deputy Commissioner, Kamrup Metro, is directed to give an opportunity of hearing to the petitioners, either personally or through their authorized representatives. The Deputy Commissioner, Kamrup Metro, shall thereupon pass appropriate speaking orders. The Deputy Commissioner, Kamrup Metro, is further directed to allot a particular area in his office wherein such replies could be submitted. A notice be hanged in the office of the Deputy Commissioner, Kamrup Metro, indicating the area. This court further directs that upon the speaking orders being passed, the Deputy Commissioner, Kamrup Metro, shall notify in its notice board about the fact that the speaking order had been passed. For a period of 30 days from such notification, no coercive measures be taken so that if the petitioners are aggrieved, they may avail remedies as permissible
Do
under.
you have any objection if the order which Mr. Choudhary is suggesting we pass in this petition?
No, Your Lordship, but then the affidavit was filed, there, it was stated, Your Lordship, that time and again, notice speaks on it.
My lord, there are 34 appellants in item number 31. And there are 154 appellants in item number 33. There we have not received any notice. Total 188.
At two,
My lord. এইটো কেছ নহয় জানো যিটো এগেইনষ্ট সুপ্ৰিম কোৰ্টৰ কেছ এইটো কোনটো এইটো কোনটো
which is that impugned notice, 10/11/2000.
Yes, my lord, impugned notice, if your lordship would kindly take Keshav Burman to kiman. Keshav Burman item number kiman.
33.
If a lot, 33 item. Volume 2 to দিব, huh? My lord, will kindly have page 825.
248.
Yes, in the earlier case. 240.
248. Lordship,
Ito kung ito matulay ko.
This 248 in the paper book,
Huh.
in the notice, 3 days, notice for eviction.
Only for 3 days, yes.
In accordance with the Assam Land Revenue Act 18, what is this 18?
No, my lord, it should be 1886 and the rules are framed there on that. Rule 18 is,
Here the title. This notice says in accordance with the Assam Land Revenue Act 18/3, 18/3/A/1.
actually rule 18, 1, 2 and 3, my lord. Now there was an amendment in 97. Now that amendment has been interpreted by the division bench where now notice is a requirement.
That's right. So this notice essentially under section 18 notice, this
It was not to individual persons, my lord, as a whole.
was general notice. That's right.
The file to go to more. 242 was it?
That reference answered by the full bench. If the copy is there.
Division bench.
Division bench.
Yes.
Reported 2024 4 GLP. 857.
Mohammed Salakuddin.
In fact, my lord, the one I have read, more or less same principles has been laid down. That if you have a bona fide claim of right, because if your lordship would kindly, a judgment to give,
Lordship, the reference of this citation is mentioned in the order and judgment which I have. paragraph 46.
237. Oh, 242 notice given है. 242.
242 can start.
Right?
Aurobindo.
Provincial, sir. Provincial.
Aurobindo to 242 for a.
Notice was cyclostyle active.
So make it, so make it.
तारीख को नहीं लगा. No, 10/11/22. देखिए लास्ट स्टेप की फोटो.
It's a circle officer and wire. PCF.
জিসির কথা কিন্তু কোট করলে
More or less, then, we will dispose of these writ appeals as per in terms of the order passed by the learned single judge. That
Yes,
is the, I think,
Yes, sir.
more particularly para 50 minute of the learned single judges order.
that is.
Thank you.
Item number 31 and 33. 31 and 33. This PIL will keep this PIL.
Yes, sir.
This, in both these appeals, the common, the order impugned is.
There are two appeals, my lord. I am appearing in item 31 and 33. 30, no, 32 is no, 31 and 33.
The notice is same date. Notice bears the same
It is
date.
same day.
Yes,
And the order impugned is also same.
Same.
yes, yes.
These two. appeals are-
Damn, I need to file law, बाकी ना.
These two writ appeals are preferred against the. Judgment.
Judgment को देखते ना, The same day.
17/11/2020
I do, sure.
passed by the learned single judge.
Judgments are also of the same day.
In writ petitions number 7338/2022 and another is
Another is your lordship.
Judgment, repeat this one. Judgment, WPC.
One is 7338/2022
One is 7159.
7159 of 22.
7159 of 22. The appellants have preferred petitions essentially challenging the order dated, challenging the show cause notice dated 18/11/2022.
10/11.
10/11.
10/11, Milord.
10/11/2022 issued to challenging a general notice
General notice,
Yes.
cyclostyle.
dated 10/11/2022 directing and 111, another is 111. 1/11/2022 and 10/11/2000.
10/11.
In vernacular, it is there, my lord. Both are 10/11.
10/11.
Okay. 10/11/2022. General notice 10/11/2022, whereby the general public was directed to vacate
Time देखते हैं लोगों से
हम्म?
एक उसका individual कोई भी नहीं to be but time देखते हैं लोगों से
land covered by the government Doug number 1076 of Takin now
edit prayer to
under Bel Tola Moja.
My lord, I must stand corrected, my lord. Actually, in one case, it is 110.
111.
111, yes.
Then लिख 111 and 10/11/2000.
10.
But area is the same. Government Doug numbers 1076 of this. That is
Same village, my lord, same area.
that is on Bel Tola Moja within a period of 3 days from the date of publication of the said notice. The learned single judge, after considering the arguments of the tribal parties, has disposed of the writ petitions wide impugned order. Wide impugned orders dated 17/11/2022. Orders are, they are of different dates. Two orders are of different dates.
My lord, in WPC number 7338,
Yeah.
the
It is
impugned
17/11.
judgment is dated 17/11/22.
Yes. And
other one is 9/11.
9/11.
so
भूल कोई तुम्हें क्या देखो
the learned single judge is disposed of the petition by the impugned orders and set aside the notices dated 7/11. And set aside the eviction notices dated 7/11/2022 and 10/11/2022. One. Respectively, only to the extent
Or it was not satisfied, they were given time, your lordship, to vacate. Or if lordship would kindly come to page 1005 and
Ma'am, please
1000.
let the order be dictated, don't it? To the extent that 3 days, to the extent of granting 3 days time to the appellants to vacate their lands. Full stop. The learned single judge has directed the respondents to give another 3 weeks time from today to the petitioner to vacate the land they are illegally occupying in terms of the eviction notices to enable them to make alternate arrangements. Learned single judge has further observed that the extension of time given to the appellant for vacating the land in terms of the eviction notices is however subject to the condition that the petitioners have already been evicted from the lands, have not already been evicted from the land occupied by them. From the lands occupied by them. Full stop. Learned Mr. Learned Senior Counsel has argued that the division bench of this court is Salapuddin, MD petitioner versus State of Assam and other, while answering a reference as passed the judgment dated 27/6/2024, whereby holding that prior to the initiation of the proceedings under Rule 18(2) of the settlement rules, the occupant possessor of the government lands has to be issued notices. It is submitted that the notices issued to the occupants possessor of the government land is to be individual notice issued to the so-and-so is to be individual notice, and considering the same, a single bench of this court has already disposed of a writ petition number 3715/2022. Judgment dated 7/11/2024, directing the respondents to issue individual notices to the alleged encroachers of the government land. It is submitted that these writ appeals can be disposed of in terms of the directions issued by the learned single judge in writ petition number 3715/2020, while judgment dated 7/11/2024. Learned counsel appearing for the state has fairly conceded that the order passed by that similar directions we issued to the respondents as has been passed by the learned single judge in WPC number 3715/2022, while judgment dated 7/11/2024. In view of the submissions made by the learned counsel for the parties, we deem it parties, this writ petition is disposed of with the following observations and directions. Number one, the respondents may issue fresh notices, may issue fresh individual notices to the alleged encroachers over the government land, for which the general eviction notice dated 7/11/2022 and 18/11/2022 were issued, under Rule 18 to vacate the government land. Under Rule 18 to show cause why they should not be evicted by taking recourse to Rule 18 of the settlement rules.
The notice dates are mispronounced by a lot.
Yeah.
Notices date, Your Lordship, one is 1/11 and the other one is 10/11.
We'll get it corrected. Second, the appellants, here the appellants in the present batch of writ petitions are at liberty to submit individual reply to the said notices along with the evidence along with the documentary evidence showing cause that they have a bona fide right of claim involved in respect of the land under their occupation, and as such recourse to Rule 18 of the settlement rules is not permissible. Third, the liberty given above is to be exercised within 30 days from the date of the respondents, the respondents may issue notices under Rule 18 to the appellants within 30 days from the said from this order. Can we get the next? The respondents may issue notices to the alleged encroachers slash petitioners within a period of 30 days from today. The appellants may file reply to the said notices within a period of 15 days thereafter. Then fourth, the Deputy Commissioner Kamru M is directed to give opportunity of hearing to the petitioners either personally or through their authorized representatives. And shall thereupon pass appropriate speaking order. The Deputy Commissioner Kamru is further directed to allot a particular area in his office wherein such replies could be submitted. A notice be placed on the notice board in the office of the Deputy Commissioner Kamru M indicating such area. Full stop. It is the next Kadena. It is further directed that upon the speaking orders being passed, the Deputy Commissioner Kamrup Metro shall notify in its notices, in its notice board about the fact that the speaking order has been passed. Till a decision is taken upon the said notices, no coercive measure shall be taken, so that if the petitioners are relieved, that may avail remedies as permissible under the law. Full stop. The Deputy Commissioner Kamru is directed to complete the said process within a period of 3 months from today. Full stop. It is also made clear that if any appellant fails to respond to the notices issued under Rule 18, the respondents are free to initiate, respond to the notices issued under Rule 18 within the time within the stipulated time given. The respondents are free to act, free to take action against, free to take action in accordance with.
Well, I was just praying for one addition, my lord. In the division bench order passed in the present PL, my lord, an observation was also made that under the land policy, my lord, the people are entitled to 1.5 cut of land. That will make an application, that also they will consider.
Settlement rules and land policy, we have.
No, my lord, land policy is there, my lord.
Land policy, we have already mentioned it.
No, my lord. If you also would kindly have a look at the order dated 6/2/23 for a moment, my lord, at page 39. The order which I placed.
In PIL.
Yes, my lord. Para 23, subpara 2. Because bona fide claim of title will also arise from this policy, my lord. if any of the persons make any individual application for allotment of land under the land policy of 2019, the deputy commissioner subject such applicant for his appropriate consideration under law and pass a reasoned order, whether in the facts and circumstances of individual, the person.
May I, Your Lordship? This has already been referred to in the Honorable Coordinate Range, Your Lordship, the order.
ये देखना second जो direction दिया है, second direction second direction if any, along with documentary evidence, if any,
Including a claim under the policy. Sorry, Miller.
yes. And as such, the recourse under Rule 18 of the settlement rules is not permissible. Not permissible. The appellants are also at liberty to make claim for allotment of the land under the land policy of 2019.
That's all.
That is already available under Vasundhara, Your Lordship. Yes, Your Lordship, they can approach. Government land, Your Lordship.
Will this incorporate this?
Miller, the only thing is because already
Not
there
in
is a
this
dividend
second
bench
para-
order.
Not in the second para, separately will deal with.
Miller.
The PL,
Yeah, that is this PIL will then list after 3 weeks.
32.
Item number 32 may list after 3 weeks.
may I submit, Your Lordship? After this PL sumoto was initiated to evict the encroachers from the government land which are allotted to the government offices and institutions, Your Lordship.
Fine.
So accordingly, the district administration are doing their part, Your Lordship.
Fine.
Your Lordship, this is a purely government land which they are encroaching, Your Lordship, it is proven. So allotment of 1.5 lectures of land, that Your Lordship in this order may not be reflected, Your Lordship. My humble prayer.
No, that is with the land policy phase, that it can't be done. They will not do.
It is only under land policy.
God bless you.
Order accordingly.
I'm obliged.
Yes.
Item 34.
See, part check of the law. Appeal lies to the Supreme Court, let's say, under section 35 L2.
So, इसके learned concept of the appellant has frankly submitted that the against the impugned order, the appeal, against the impugned order, the remedy available to the department, to the revenue is to file before the Honorable Supreme Court under
Section 35L2,
35L
L, capital L.
and two in bracket,
Yes, Lord.
L2 of the ITL,
Central Excise Act 1944.
Central Excise Act 1994. And therefore, he feels that he may be allowed to withdraw this excise application with liberty to avail the remedy available to the department, avail the remedy of the appeal available to the department.
Lord.
Dismiss with liberty as grateful.
For hearing, item 41 and 42.
Lordship, before Lordship take up that, I have a 36 item number, hearing matter. I pray that matter may be taken up some other time.
Today, we are not taking any hearing matter because one matter. part of
Lordship,
matter
yes,
is already
Lordship,
pending.
Watch it.
This is the, we'll take it only that.
6 and 37.
36 and 37. both.
Yes. Item 41 and 42.
Yes. Before my learned friend starts, I would like to submit that. Let him continue, Lordship. I have also few very pertinent judgments to place, Lordship. If he completes, then I can place it to close it. Lordship.
We are doing this only observe. Because we are hearing these matters and you can very well.
Place it, because otherwise I have placed fewer judgments. I could find some very pertinent one.
Yes, 1 second. Yeah.
Made. My lord, the basic.
Just.
One five nine one to be normal issue है.
Adjustment.
Education code.
1994. Paragraph 2 ले दे paragraph 2 ले दिया पर नंबर तो दिया paragraph let's take down 7 B let's take down next citation to what you know Era
Just to put our case in perspective, my lord, I'll read one paragraph from the writ petition and I'll also place our prayers, my lord.
The petition which.
My lord, 1414. My lord, in 1414, the challenges to the TET cum recruitment test. And in the other case, same subject, graduation and post-graduation.
Post-graduation, these are the two challenges. Yes.
Para 16, page 22, my lord. Because the learned advocate general also made a submission that he is confused as to what is our prayer, what is our case. In that context, my lord.
Yes.
The petitioner begs to state that impugn amended provisions of Rule 8, 10.1, 10.2 and Schedule 2 of the amended service rule brought in white notification dated 29/23 and 13/12/23, compelling the petitioners to sit again in the TET examination, apart from being violative of the decision of NCT, that validity of TET would be valid for a lifetime is also arbitrary. The NCT regulation 2014 have been framed in exercise of the power conferred under provisions of NCTE Act 1993. NCT Act has been enacted by the Parliament with reference to entry 66 of 7 Schedule List 1 of the Constitution. There is no such specific power vested in the state legislature under 7 Schedule List 2 to make laws in respect of education. Entry 25, Schedule 7, List 3 provides the field of legislation for both to the state and the central government in relation to education, including technical education, medical education and universities, vocational and technical training of labor, etc. The field of education is primarily covered by union list, and the state can exercise legislative power under entry 25 of List 3, but such law cannot be repugnant to the central law. It is a trite law that wherever the state law is irreconcilable with the central law, the state law must give way in favor of the central law to the extent of repugnancy. What is further noticeable is that impugn amendment is ultra-vires on the failure of the state respondents to follow the procedure prescribed in Article 254(2) of the Constitution of India. As such, in the humble submission of the petitioners, the impugn amended provisions of Rule 8, 10.1, 2 and Schedule 2 of the amended service rule of 23 brought white notifications dated so and so, compelling the petitioners to appear in TET are in violation and repugnant to the constitutional provision, hence liable to be struck down. Now, my lord, will kindly come to the prayer. At page number 31, my lord. One, a declaration should not be issued to the effect that the impugned provisions of Rule so and so are ultra-vires the Constitution of India as well as NCT guideline. Then please come to prayer number 2 at page 32, my lord. A writ in the nature of certiorari shall not be issued for setting aside quashing the advertisement issued on so and so, so and so. 3. Mandamus shall not be issued directing respondents to forthwith recall, resign, giving effect to advertisement dated so and so, insofar as the criteria fixed for selection of so and so is concerned. So these are the 3 prayers, my lord. The fact that, my lord, we do have TET qualification, my lord, that is an aspect. My lord, lots will appreciate. There's a concept in administrative law, my lord. There cannot be any waiver of fundamental right. In Baseswar Nath's case, my lord, Supreme Court has evolved that principle. There cannot be any waiver.
What we understand.
Yes.
The advocate general has submitted that. Here you are opposing this introduction of the TET test in the by way of amendment in the rules of 2023 by way of it. And at the same time, you are asking.
I'm coming to that.
At the same time, you are asking that this TET qualification which you are already in possession, recognition be given to it. Now you are
that prayer we have not made. It's a narration of facts. No, well, that's what I'm trying to explain.
That what you are asking for that, because you are saying that since already we are TET qualified, where is the question of going, why?
No,
why
not
we should
precisely
go for
that.
another-
No, no, my lord. In the facts, in the situation where we are placed now, where there is an amendment to the rules,
Yeah.
whereby they have introduced TET cum eligibility test. In that we say, you can't even have TET, forget of test. Forget of test, you can't even prescribe a TET. That is the context.
That is the context.
Yes.
And at the same time,
Huh.
you are also.
No, we are not staking any claim. Lordship will not allow that claim of ours. Merely because we are TET, on that Lordship will not allow our claim. My lord will kindly
I
see.
understand, because your claim was that since you are already TET
No, no, it's
qualified.
not that. Kindly see, that's why I've read the prayer, my lord. Where have we made that prayer? That's why I read the prayer. That's why I said, I must place the facts in perspective. Our facts are very clear. My lord, it is the narration of facts that we do have a TET qualification, which is valid for 7 years. In that context, I'm not saying. What we are saying is, forget of anything else. You can't even have TET. Forget about TET cum eligibility test.
So earlier also, whatever the provision regarding that was also not in accordance with law.
Yes, yes. And in fact, my lord, that position is under challenge. That writ petition is pending. In WPC number 5557 of 2017, my lord, Sanjeev Doimari versus State of Assam, that petition is pending. It is in the hearing list, na? It is in the part 2 list.
That is now infectious.
Yes.
The infection of this.
No, my lord, I think this is not infractions, my lord. That is pending.
No, that is pending, but
Yes.
with this amendment now that is infected.
No, but in amendment also TET in a different form. So therefore, my lord, this is not, it's not that something which is unintelligible. তুমি এইটো কথা judgment টো para 16 আৰু কবা ইয়া কমপ্লেইনৰ ওপৰত বেছ কৰি এটা কৰে নৰ্মেল যিটো মানে এডমিনিষ্ট্ৰেটিভ এক্সিজেন্সি বা পাব্লিক ইন্টাৰেষ্টটো কনচিডাৰ কনচিডাৰেশ্যন জামিন আৰু নট কনচিডাৰ
Yes.
Yes. So my lord, our pleadings and our prayer are very specific. The fact that, my lord, we appeared in that earlier examination, we got TET, that cannot come in the way, my lord, for the simple reason, my lord, we are entitled to equal protection of law. We are entitled to a declaration that the impugned amendment is repugnant. So to that extent, my lord, we have a right. That right, my lord, even if we want to waive it, we cannot. That is, my lord, AIR 1959 Supreme Court Constitution Bench decision, my lord, 149. AIR 1959 Supreme Court 149. Basesar Nath versus my lord Commissioner of Income Tax. Pena. Yes. My lord will kindly come to page 181. My lord, Article 13 is quoted thereafter. The sentence starting with this article. My lord, para is 82, but I'll have your lordship's kind attention to page 181 on the left-hand side top, the sentence starting with this article in clear and unambiguous term. That means Article 13, my lord. 181. This, can I read, my lord? Yes. This article in clear and unambiguous terms not only declares that all laws in force before commencement of the Constitution and made thereafter, taking away or abridging the said right would be void to the extent of contravention, but also prohibits the state from making any law, taking or abridging the said right. Part 3 is therefore enacted for the benefit of all citizens of India in an attempt to preserve their fundamental rights against infringement by institution created by the Constitution. For without that safeguard, the objects adumbrated in the Constitution could not be achieved. For the same purpose, the said chapter imposes a limitation on the power of the state to make laws in violation of those rights. The entire part, in my view, has been introduced in public interest, and it is not proper that fundamental right created under various articles should be dissected to ascertain whether any of which part of them is conceived in public interest and which part of them is conceived for individual benefit. Part 3 reflects the attempt of the Constitution makers to reconcile individual freedom with state control. While in America, this process of reconciliation was allowed to be evolved by the course of judicial decision, in India, the fundamental rights and their limitations are crystallized and embodied in the Constitution itself. While in America, a free hand was given to judiciary not only to evolve the content of right, but also its limitation. In the Indian Constitution, there is not much scope for such process. But this is important. The court cannot therefore impose any further limitations on fundamental right other than those contained in Part 3 by a doctrine such as waiver or otherwise. I would therefore hold that fundamental rights incorporated in Part 3 of the Constitution cannot be waived. Even if a citizen waives, my lord, court will still come to the rescue. So therefore, this argument, in my humble submission, may not be of any substance. Now, my lord, my friend, Learned Advocate General has articulated his arguments on 2-3 points. And one of the point is NCT guidelines prescribe minimum qualification. Therefore, there is no power to prescribe higher qualification by the state.
This is the main argument.
Yes. My lord, with utmost respect, my lord, with all humility at my command, this judgment is absolutely fallacious, my lord. There's no concept like that. But there's nothing like minimum or higher. What the concept is whether one has the qualification which is required to hold particular post. And my lord, state government need not appoint any expert. The expert is NCT. The Constitution has conceived that NCT is the expert. So my lord, state government has no role to appoint any further expert. No amount of committees report cannot substitute their effort.
But what about those, some of the judgments?
I'll show, my lord, how those judgments are relevant in this case. The judgment is an authority for what it actually decides. But the judgment is not to be read as a statute.
Supreme Court has said several occasions. I'll place all the judgments. I'll show, my lord, how the two judgments referred to by my learned friend are judgments rendered on the facts of the case. It does not lay down any principles of law. My lord, what is a ratio decidendi? A ratio decidendi can be a judgment will attain the status of having a ratio decidendi when it decides on a principle of law. Now, what is the principle of law in these two cases? I'll show, my lord, it's not. So, my lord, there is nothing to the contrary. My lord, these are not the only two judgments of the Supreme Court on the point of repugnancy, my lord. There are plethoras of judgments where the Supreme Court has ruled otherwise. Therefore, my lord, my humble submission is, first part is, my lord, lords will have to consider a judgment is an authority for what it actually decides. Every sentence, every observation in a judgment is not ratio. Similarly, my lord, a judgment is not to be read as a statute. Well, I'm placing the judgment for a moment. My lord, this is AIR 1968 Supreme Court. AIR 1968 Supreme Court 647. It's again a constitution bench judgment, my lord. State of Odisha versus Sudhanshu Shekhar Mishra. AIR 1968 Supreme Court 647. 81, no? Relevant portion. Yes. My lord will kindly come to page number 651. If your lordship kindly comes to right hand side at page 651, my lord. Before the, my lord, for subpara starts, 5-6 sentence above, a decision is only an authority. Has your lordship got it, my lord? At page 651, a decision is only an authority for what it actually decides. What is of essence is a decision in its ratio and not every observation found therein, nor what logically follows from the various observations made in it. So this is the essence of how to read a judgment. Because on what, that's why, my lord, the fundamental requirement is to read the facts. On what facts a judgment is rendered. It is that judgment which lays down a principle of law will have, my lord, binding effect. My lord, on this point, I'll refer to one more judgment.
After constitutional bench judgment?
Yes, my lord.
After constitutional bench judgment?
No, there's one, my lord. That's a very important, my lord. That judgment is that Islamic Academy Education, my lord, after TMA 5 judgment, several states frame regulations, my lord. There were some misunderstanding regarding what is the ratio in TMA foundation. Supreme Court explained that there, my lord, the principles has been laid down. 2003 6 SCC 697. This is again a constitution bench judgment, my lord. 2003 6 SCC 657. 697.
697.
That is 697.
Yes, my lord. Please come to para 139. The heading is interpretation of a judgment.
Yes.
A judgment, it is tried, is not to be read as a statute. The ratio decidendi of a judgment is its reasoning, which can be deciphered only upon reading the same in its entirety. Ratio decidendi of a case or the principles and reasons on which it is based is distinct from the relief claim finally granted or the manner adopted for its disposal. See, so and so, so and so, so and so. Now, my lord will kindly go down. If your lordship kindly comes to para 146. Why this observation had to be made, my lord? Rather 145 and 146. It is further tried that a decision is an authority for what it decides and not what can be logically deduced therefrom. The judgment of this court in TMA Foundation will therefore have to be construed or to be interpreted on the aforementioned principle. Cannot reach some sentence from here and there to find out the intent and purport of the decision by not only considering what has been said therein, but the text and context in which it was said. For the said purpose, the court may also consider the constitution or relevant statutory provision vis-a-vis its earlier decision on which reliance has been placed. So, my lord, my humble submission is to consider or to, my lord, take note of what my learned friend has argued. Lordship will have to take note of this principle. I'll show, my lord, how those judgments are distinguishable. Now, 97. Now, first, my lord will kindly come to this Pretty Srivastava's case, which my learned friend placed. 1999, 7 SCC 120. Now, let us see, my lord, what were the facts of this case. Please come to para 4 at page 141.
Yeah.
This government order of 31/8/95 was challenged before this court in Dr. Sadhana Devi versus State of UP. This court, by judgment dated 19/2/97, held that while laying down the minimum qualifying marks for admission to postgraduate courses, it was not open to the government to say that there will be no minimum qualifying marks for the reserved category of the candidates. If this is done, merit will be sacrificed altogether. This court struck down the government order dated so and so. So that order was interfered by the Supreme Court in Sadhana Devi. After the said decision of the State of UP issued an order, geo dated so and so, whereunder cutoff percentage of marks for reserved category candidates were restored at 35. However, the State of UP moved an application before this court being IA number so and so, in which State of UP inter alia prayed that it should be given the liberty to reduce the cutoff percentage from 35% to 20% for reserved category candidates who appear in PGMEE for 1997. Without waiting for a decision, by an ordinance dated 15/6/97, State of UP reduced the minimum qualifying marks for reserved category candidate appearing in so-and-so form 35 to 20%. This ordinance is challenged in the present writ petition, that is so and so. Ordinance has now been replaced by Uttar Pradesh Postgraduate Medical Education Reservation for Scheduled Caste, Scheduled Tribe, and other Backward Classes Act 97. The petitioners now have amended the said writ petition to challenge the act. For admission effected in 98, State of UP again prescribed a cutoff percentage of 20 marks for reserved category candidates. Learned Counsel for the State of UP has further stated that for the current year's admission, for the admission to PGMEE 99, State has introduced a bill in the Legislative Assembly prescribing the same cutoff percentage of 20 marks for the reserved category candidates. So this was the challenge, Miller. That means for admission to postgraduate in medical, Miller, they're proposing that minimum 25% marks for reserved category. Now, issue is which will eventually Supreme Court say this is an issue which was not covered by the MCI guidelines. That is why this order was given, my lord. Now, my lord will kindly come to paragraph 12. Why Supreme Court permitted this? Article 15(4), which was added by the Constitution First Amendment of 1951, enables the state to make special provision for advancement inter alia of scheduled. Yes, ma'am.
Actually, what you are the question before court was they have mentioned in para number 2.
Yes. Yes. Now, my lord, to cut short the whole thing, if your lordship would kindly come to 161, then answers. Please come to 161, 116 para. Why Supreme Court said this, my lord? Because this was an area which was not covered by the central legislation. I have placed the judgment of Justice Rohington Nariman and Honorable Justice, I forgot the name, my lord. There, one of the principle is that if on a particular area, there is no central prescription, state can make. Yes. Para 116.
Para 116.
Six, yes, my lord, pet 207.
Yeah.
It is permissible to the state authorities which are running and or controlling medical institutions in the states concerned to shortlist the eligible and qualified MBBS doctors for being considered for admission to postgraduate medical courses in these institutions. For the purpose of such shortlisting, full play is available to the state authorities to exercise legislative or executive power, as the field is not occupied till date by any legislation of parliament on this aspect in exercise of its legislative power under entry 25 of list 3, and this topic is not covered by any legislation under entry 6 of list 1. This is the reason, my lord. Now kindly come to me, lord. 2. Indian Medical Council Act regulations framed therein do not cover the question of shortlisting of admission of eligible and duly qualified MBBS doctors who seek admission to different medical institutions, imparting postgraduate education run or controlled by the state. These are the distinguishing features, my lord. Then my lord will kindly come to 5. Now, why it was permitted, that is also the one of the reason. It is equally permissible for the state authorities, while undertaking the aforesaid exercise of shortlisting, to fix 50% minimum qualifying marks at the entrance test for the general category candidates, and to dilute and prescribe lesser percentage of passing marks for reserve category candidate as exigencies of situation may require in a given year, but in no case the minimum qualifying mark as reduced for the reserve category candidate can go below 25% of the passing marks for such reserve category of candidates. In other words, a play is available to the state authorities to prescribe different minimum passing marks for SC, ST and OBC eligible candidates between 50% and 25% as the prevailing situation at the given point of time may require. In such categories, SC, ST, OBC candidate, different diluted passing marks can be prescribed. But this exercise has to be within the permissible limit of less than 50% and up to minimum of 25% passing mark for each such reserve category candidate. No eligible candidate belonging to reserve category who does not obtain minimum percentage of passing mark as diluted for such category of candidates by state authorities can be considered to be eligible for undertaking postgraduate medical courses in a given year for which he has offered his candidature. And if any seat reserved for such categories of candidates remain unfulfilled due to unavailability of such eligible reserve category candidate to fill up such a seat, then the said seat would go to general category candidate and will be available in order of merit in the so and so, so and so. Now, Yes. My lord will kindly come to last two sentence at page 208.
Yes.
At page 208, subpara 5 of para 116. The aforesaid practice has to be followed and should hold the field from year to year, so long as Parliament does not pass any legislation for regulating admission to postgraduate medical courses, either by separate legislation or by appropriately amending the Indian Medical Council Act by empowering Medical Council of India to prescribe such regulation. So, my lord, it is a case where either the MCI Act or MCI regulation did not cover the field. It was in that context, my lord, the Supreme Court recognized the power of the state. Therefore, this judgment is a judgment given in the facts of this case. It is not a ratio, my lord. That the state law would not be repugnant if it is otherwise, my lord, not reconcilable with the union law. So that principle has not been diluted by Supreme Court in any case. What the paragraph was saying, 52 maybe.
Yes.
My lord, one more paragraph is important, para 52 of the judgment. Page number 162.
Yes. Yes.
Mr. Salve, learned counsel appearing for the MCI, has therefore rightly submitted that under the Medical Council of Act of 1956, an Indian Medical Council is empowered to prescribe inter alia standard of postgraduate medical education. In the exercise of its powers under Section 20-33 has framed regulation which govern postgraduate medical education. These regulations therefore are binding, and state cannot, in exercise of its power under entry 25 of list 3, makes rules and regulation which are in conflict with or adversely impinge upon the regulation framed by the Medical Council for postgraduate and medical education. Since the standard laid down are in exercise of power conferred under entry 66 of list 1, the exercise of that power is exclusively within the domain of union government. Power of the state under 25 is subject to. This is the principle of law. This principle of law does not help the state. This is contrary to what my learned friend is arguing below. This was not in the facts of this case different, but this is the principle of law.
Yes.
My lord, following Preeti Srivastava, this 2004 SCC was rendered. Kindly see the facts of this case, which was referred by my learned friend, my lord. 2004 SCC 513.
2002, 4.
2004, my lord.
2004 or 2002?
State of Tamil Nadu versus SB Pratap Mahajan.
2004?
4. Now, my lord will kindly come to page 515, para 3 for the facts.
Yes.
The learned single judge of the High Court who examined the matter held that prescription of qualifications or prescription of minimum eligibility mark for ST/ST as mere pass most backward at 50% average marks in the related subject, backward at 55% average marks in related subject, and other categories at 60% average marks in the related subjects would not be in conflict with the regulation of All India Council for Technical Education and therefore dismiss the writ petition. So learned single judge of the High Court, my lord, dismissed the writ petition despite noticing that these were given. Against that, writ appeal was preferred, writ appeal was allowed. Against that, writ petition, Supreme Court, they went. Now kindly come to para 5. So what is the difference between the central prescription and, my lord, the prescription by the state authority? Para 5 at 517. We shall now examine only the question posed before us as to whether the norms prescribed by the state government are contradictory to the norms fixed by the AICTE or are only in the nature of higher qualification above the minimum prescribed by AICTE for admission to engineering colleges. AICTE prescribed qualifications in their guideline for the relevant period as follows. Qualification for admission of general category student is separate, my lord. Then kindly come to 1.3. All state union territories should conduct entrance test in the subject of physics, chemistry, and mathematics at 12 plus level. Entrance test should be common to all engineering degree institutions in the state UTs. The minimum marks for eligibility for entrance test need not be prescribed in the case of degree courses, and all students who have passed the qualifying examination may be permitted to appear in the entrance test. Only the merit ranking in the entrance test should be the basis for admission to the engineering degree. Such tests should be conducted by appropriate agencies set up for the purpose. So this was the prescription by the AICTE, and what was prescribed by the state is, my lord, they said reserve category would require lesser marks and general category would require higher marks. Why it is permitted? Because referring to Article 15(4) in Pretty Srivastava, Supreme Court says that is permissible. Only thing is, the seats should be confined to 50%. That is why, my lord, if your lordships will kindly come to paragraph, yes, para 8. Para 8, my lord. As regards the scope of entries in the Constitution arising under entry 6 list 1 and entry 25 list 3 of the 7th schedule to the, it was examined in great details by Constitution bench in Pretty Srivastava. After adverting to these two entries, this court stated as follows. Now kindly see, my lord, what was said. Now, end of the day, my lord, in Pretty Srivastava, Supreme Court took note of Article 15(4), which permits that you can give some relaxation to reserve category candidates. And that has been done, nothing else. So in that context, Supreme Court said it is okay. But in our case, my lord, there is a prescription. What would be the qualification required for a particular post? Now the issue is, can state go beyond that? Whether it is higher or lower is not the issue. Whether the qualification prescribed is in consonance with the qualification prescribed by NCT. That's the point, my lord. Now, my lord, on this point, there is a direct Supreme Court judgment, my lord.
That you already referred.
No, there's one more, my lord. I don't want to In fact, it's a case from, my lord, Rajasthan High Court. If your lordship would kindly come to para 66. One important aspect of the present case must now be dealt with, on which much emphasis was laid by the counsel for the appellant. Submission is that the central government in any case is the final authority in deciding as to what qualification has to be there for teachers, and NCT is bound to follow the directions of the central government in this regard. The reliance was placed on the provisions of National Council for Teachers Education Act, so and so. We must examine this provision. What happened in this case, my lord? Contrary to the prescription of the NCT Act, my lord, for primary school teachers, state of Rajasthan, my lord, brought in the prescription of BA. But what was prescribed by the Act is, my lord, DLA. DLA. It was in that context. Now, my lord will kindly come to para 71. NCT is bound to follow the directions of the central government in this regard, and direction in the present case was to include B.Ed as qualification for teachers in primary school, which has been done by NCT through notification dated so and so. are the submission of the learned counsel for the appellant as well as that of the learned ASG, Sri so-and-so on behalf of the Union of India. Moreover, as per subsection 2 of section 29, the decision of the central government as to what constitutes a policy will ultimately matter is also the argument. The introduction of B.Ed as a qualification by NCT on the direction of the central government is a policy decision of the government as has been submitted before this court and is also evident from the sequence of events. The minutes of the various meetings and other orders passed in this regard. Section 29 of the NCT Act, which mandates that NCT must follow the direction of the central government in discharging of its function. It is a policy decision which binds NCT. This was the central government's argument. We have absolutely no doubt in our mind that policy decisions of the government should normally not be interfered with by the Constitutional Court in exercise of its power of judicial review. At the same time, if the policy decision itself is contrary to law and is arbitrary and irrational, power of judicial review must be exercised. Then my lord will kindly come to para 79 and 80. In the present case and in the larger context of the matter, we cannot even see this as a policy decision. But without getting into this argument, even presuming for the sake of argument, the decision taken at the government level to include B.Ed as a qualification for teachers at a primary level is a policy decision, we must say that this decision is not correct and it is contrary to the purpose of the Act. In fact, it goes against the letter and spirit of the fundamental right enshrined in the Constitution under Article 21A. It is against the specific mandate of the Act, which calls for a free, compulsory, and meaningful primary education to the children. By including B.Ed as a qualification for teachers for primary school, the central government has acted against the provisions of the Constitution and the law. The only logic given by the central government to include B.Ed as a qualification is that it is a higher qualification. This we have already seen is not correct. Under these circumstances, we have no hesitation to say that notification has rightly been passed and the decision of the division bench of the Rajasthan High Court has to be upheld. So, my lord, this is a clear authority for the proposition that if a prescription is given which is against the constitutional mandate, where we say here it is a repugnancy aspect, my lord, it has to be interfered with. Now, my lord, এইটো কি আছিলে? My lord, my learned friend, the learned advocate general has also relied on this judgment, my lord. 2022-12 SCC 42 regarding, my lord, history that it includes different branches, my lord. That was a judgment, my lord. This is neither here nor there on the facts of that case. But I don't think any ratio is discernible in that case, which will bind your lordship in the present case. Here we have a simple case where there is a prescription by NCT and there is a prescription by the state. Both are in conflict. Now the issue is which will prevail. So in my humble submission, my lord, the prescriptions by, NCT must prevail. Now, my lord, in a 226 jurisdiction, your lordship is concerned with the decision-making process. For a moment, lordships will not go into what is the merits of the case. My lord, all throughout what my learned friend was arguing, he was trying to highlight the merits of the decision. My lord, it could be a very good decision. But if the procedure adopted to arrive at the decision is wrong, then, my lord, the Constitutional Court will have to interfere. Now, all that we are saying is, there is a procedure to get over this. The procedure is Article 254(2). That you have not adhered to. Therefore, it is fatal. Now, my lord, so, my lord, as far as the first case is concerned, where TETCOM eligibility test has been prescribed, these are my submissions, my lord. I'll not, trouble your lordships in any other authorities. So, my lord, these are my submissions. In my humble submission, subject to what your lordships may say, it's an open and shut case, my lord. Because, my lord, I have referred to the judgment by, I'll not place it, I'm just referring to that, my lord. Yes, that 2018 1 SCC 407, where in paragraph 51.7, my lord, it was clearly said, I'm just reading it, negatively, my lord, 2018 1 SCC 407, while opening my argument, I have placed the judgment, my lord, on para 51.7, last three sentence, placetam E. Negatively put, where parliamentary legislation does not purport to be exhaustive or unqualified, but itself permits or recognizes other laws restricting or qualifying the general provision made in it, there can be said to be no repugnancy. In fact, Preeti Srivastava is a case, my lord, which falls in this category.
5.5.
51.7, my lord.
51.7.
Para, yes.
Page.
My lord, page 460. My lord, in this case, in para 51, these situations has been visualized where it can be said that there is repugnancy. 51.7 at page 460, placetam E, my lord. Negatively put, where parliamentary legislation does not purport to be exhaustive or unqualified, but itself permits or recognizes other laws restricting or qualifying the general provision made in it, there can be said to be no repugnancy. So my humble submission is, my lord, subject to your lordships may say, Preeti Srivastava falls in this category. No, my lord, just two more, paragraphs, my lord. I'll conclude, my lord. Now, as far as, my lord, the scope of reading a judgment, one lordship will kindly permit me to place one paragraph, my lord. 1971, 1 SCC 85. It's a judgment by 11 honorable judges of the Supreme Court, my lord. My lord, what was challenged in this case was, my lord, abolition of the privy purse. If your lordship would kindly come to page 165, last three sentence of para 141. The sentence starting is, it is difficult to regard. I'm sorry, Miller. Page 165, last three sentence of para 141.
Yes. It is difficult to regard.
Yes, it is difficult to regard a word or a clause occurring in a judgment of this court, divorced from its context, exposition of law on the when question did not fall to be answered in that judgment. Now, in Preeti Srivastava, did similar situation prevail, my lord? In 2004 judgment referred by my learned friend, whether similar question appeared? So these are the questions. Now regarding the other judgment, my lord, the other case, my lord Justice Unikrishnan Nair has pointed out Schedule 3. It stands unamended. Please come to that 2018 rules, my lord. Scheme 18 rules. Page 54, my lord. Schedule 3,
Is a notification is that page?
no, my lord, I am referring to that rules.
But, you see, notification.
Yes, yes. 45.
Yeah.
In the principal rule in schedule 3, in clause 1, in the fourth line after the words as valid for the punctuation mark shall be substituted and thereafter the following words shall be inserted, namely, candidates shall have to read the same subject as one of the subjects in degree level. Now kindly see one, my lord. It does not prescribe, it remains the same. Kindly see, my lord. Postgraduate with at least 50% marks from recognized university and bachelors of education of so and so, so and so, so and so, but degrees obtained from off-campus distance situation, they shall not be considered. No, even if it adds, my lord, there is no clarity. That's what I'm trying to submit, my lord. They add to it, I know. But where is the express requirement? Where is the express requirement? And one more aspect, my lord. Assuming, my lord, what state is saying is correct. Now, my lord will kindly come to page 43, the advertisement. Thus, we'll have to give some meaning to this also. Too small d. D, small d, my lord.
There shall be one.
There shall be one common question paper for all vacancies, irrespective of the subjects for postgraduate teachers recruitment. If they are so concerned, if their experts, my lord, have said that the person having a graduation in the same subject as well as in post-graduation alone are eligible, how come they are assessing the merit, my lord? There will be a common test irrespective of the subject. Does it stand to any logic? Therefore, my lord, the views of the expert of the state will not prevail because the constitution has specifically earmarked the job to the, my lord, central government or to the nominee of the central government. And NCT does not say so. NCT is supposed to be the expert. There cannot be any better expert in this pool, my lord, to prescribe further higher qualification. Kindly see how they are going to judge. You are making an advertisement. You are laying down the terms and conditions. Is this the terms and condition? There shall be one common question paper for all vacancies, irrespective of the subject for the postgraduate teachers recruitment. How does one reconcile this, my lord, with the avowed object of the state, which they seek to pursue? Therefore, my lord, end of the day, my lord, these are all malice in law. Because whenever a decision is taken without taking note of relevant consideration, my lord, then these actions are to be treated as suffering from vice of malice in law. Therefore, in my humble submission, my lord, both these writ petitions where we have laid challenge to the validity of the impugned rules, my lord, Lordships will uphold the challenge and interfere with the impugned rules.
Mr. Chaudhary,
Lord,
please answer one thing.
yes,
In this 2018 amendment,
yes.
is a page,
In the second case, my lord,
first case, second case, anyway.
yes, yes.
63. At 60,
Page 63, my lord,
62,
yes.
they would have this, or rather, this, this page 58, page 58.
Yes, my lord,
In principle, the rule following shall be substituted.
yes.
The recruitment to be posted the cadre postgraduate teacher, including subject teacher in vocational subject, shall be made by direct recruitment. If they would have not mentioned this, through the teacher's eligibility test, and only with direct recruitment through a recruitment test to be held as per the criteria mentioned, then if they have not mentioned that, this
No,
test-
my lord, no, will not.
teacher's eligibility test come recruitment.
My lord, lordship, while testing the validity of a law, my lord, legislation, lordship will give meaning to each and every word. My lord, we cannot visualize a challenge. What would have been the position, the fact that that word is that as fatal, my lord, is our humble submission, my lord.
Maybe, what I'm saying, if they would not have mentioned it, then
No, if it is not mentioned, then that is not required.
but in this recruitment test,
Yes.
this
Recruit, teachers eligibility test come recruitment test, hereafter called TET come recruitment. But now they have qualified. By the second sentence, they have qualified.
we are just saying that if this word was not there, then
The
what would
second
be the
sentence,
challenge? What would be the challenge?
perhaps my lord, the second sentence has qualified the whole thing. Hmm.
Yes,
That's my humble submission. My lord, will you kindly excuse me, there is one matter in that's what.
Earlier, my submission was, Lordship, that I am little bit confused whether they want that or they do not want that. Now today I am further confused. The
also
state,
confused.
because they want the advertisement at one hand, go.
You need some.
No, no, Lordship.
Good rest and.
That is why, Lordship, it's very difficult sometimes.
Thus, is throwing a party.
The pollution control board is here. Because in the next case, we are together, but here now, if Lordship is pleased to look at their prayers. Prayer number 3, page 32. Mandamus shall not be issued directing the respondents to forthwith recall, resign, cancel, or forbear from giving effect to the advertisement dated 27 so and so. They want, as paragraph 2 also, a certiorari to set aside the advertisement. And if Lordship is pleased to come to their prayer at D, direct the respondents to allow the petitioners to participate in the selection process in response to the advertisement dated 27/12. So they want both. The advertisement should go, the advertisement should be set aside. Number on one hand, and the other hand, they wanted mandamus from this honorable court to allow them to participate in the recruitment.
Alternate.
On one hand, they say that that is bad. But at the same time, there are also one line, my learned senior friend placed paragraph 16 up to page 23. He did not go to paragraph 17 where he has said, if Lordship is pleased to come to page 24.
Yes.
by amending Rule 8 of the Rules of 2018 to the extent that recruitment to the post in the cadre of postgraduate teachers and graduate teachers, including subject teacher in vocational subjects, shall be made by way of direct recruitment through TAP test. The respondents have compelled the petitioners to once again sit in the TAP examination, that too without any valid and cogent reason. Be it stated that TAP qualified certificates issued to the petitioner are valid for lifetime, which is evident from the letter dated 9/6/2021. Therefore, the respondent cannot ignore the said fact and take recourse to the impugned amendment of 810 of Schedule 2 so and so. So they want the TAP which they are having and on the basis of which they have already obtained a lifetime certificate. So that should sustain. Yes.
7 years. But 7 years.
Initially it was 7 years. Now it has become lifetime. They can go for even betterment also now. The first certificate was for 7 years. So it is not an alternate period that they want the advertisement to remain and they want to set aside the said advertisement.
It's only for 7 years, sir. That lifetime is for primary.
Yeah.
For the NCT,
No, they have made a very categorical statement that
they only made a
if it was for lifetime, it was given lordship. It's 7 years is always there, but there is an order. Page 56. The NCT extension of validity period of teachers eligibility test certificate regarding that is a notification of the NCT dated 9/6/2021. Here, the earlier 7 years period has been replaced by the validity period of that qualifying certificate for appointment unless otherwise notified by the appropriate government would remain for valid for life. This is again a little bit dispelled. Lordship may be absolutely correct that it was earlier notified to be 7 years unless otherwise notified by the appropriate government. So if that be the case, then it is 7 years, Lordship. But their pleadings is that on the basis of this, their certificate is for lifetime. Because all the certificates, there's a specific mention would remain for valid period of for 7 years from the date of issue of the certificate which they have annexed.
Yes.
So if we conjointly read this, then it is 7 years, Lordship. Now, lot of submission has been made regarding PT Srivastava's case, Lordship.
Yes.
So regarding the interplay between entry 66 of list 1 and entry 25 of list 3, a detailed judgment has come where the state of Assam is a victim. I mean, Lordship, the state of Assam formulated an act in the year 2004 called Assam Rural Health Regulatory Authority Act 2004. It was in conflict with Indian Medical Council Act. So that Rural Health Service, my Lord Justice Nair would definitely know about this. So there is a conflict between the MCI regulations as well as vis-a-vis the state regulation relating to rural health. This judgment went up to the Supreme Court, and on 24th this January 2023, the Honorable Supreme Court was pleased to uphold the division bench judgment of this Honorable Court. Because in that case, the state wanted to take the permission, this assent under 254(2). Till the last moment, it did not come. So that is the reason why it could not be sustained in the state level, and this Honorable Court had rightly found it to be in conflict with the central legislation. While some of the students who completed the courses, they went to the Supreme Court, Baharul Islam and others, they challenged it before the Supreme Court. And the Honorable Supreme Court reported in 2023 SCC, 2023 SCC online, SC page 79. Here, without going to the facts, Lordship, a special paragraph has been laid down with the heading interplay between entry 66 of list 1 and entry 25 of list 3, the detailing what are the nuances and the nitty-gritties between these two entries. Paragraph 40, it will be page, Lordship, I am not having
40.
40. All the judgments, including Peti's reversed over, all the other connecting judgments are discussed and some observations are given. These are not passing comments, as my learned senior friend wanted to say about Peti's reversed over case. These are not passing comments. These are the principles laid down by the Honorable Supreme Court. Irrespective of whatever the facts, what is the core issue? The core issue is whether state government can prescribe something beyond the prescription of the central authorities. That is the core issue.
Yes, which paragraph you want to?
Paragraph 40, Lordship. I would like to place this is a long paragraph, lot of judgments are decided. The relevant portions I would like to place.
Yes.
Since this appeal concerns interpretation inter alia entry 66 of list 1 and entry 25 of list 3, it would be useful to refer to the following decisions of this course which examine the interplay of the aforesaid entries. Gujarat University Ahmedabad versus Sri Krishna Ranganath Madhukar, year 1963-1973. 703. So this judgment is also there. This is quite early. May I read it, Lordship? In Gujarat University Ahmedabad versus so-and-so, year 1963, the contest before a constitution bench of this court pertain to fixation of exclusive medium of instructions in university education and the legislative competence of the state legislature to do so. This court considered inter alia the question as to whether Gujarat University Act 1949, which authorized the university to prescribe Gujarati or Hindi or both as an exclusive medium of instruction and examination in the affiliated colleges, would infringe entry 66 of list 1. One of the arguments raised in the case was that under entry 66 of list 1 of the 7th schedule, the power of coordination and determination of standard in institution for higher education or research in scientific and technical institution was conferred upon Parliament, and that these matters must be regarded as having been excluded from entry 11 of list 2, which read as under. Earlier it was in list 2 also, that concurrently is entry 25. Education including university subject to the provisions of entry 63, 64, 5 and 66 of list 1 and entry 25 of list 3. Addressing such a contention, Justice so-and-so, speaking for the majority, observed that the power of the state legislature to legislate with respect of higher scientific and technical educational, vocational and technical training of labor is controlled by the 5 items in list 1 and list 3 mentioned in entry 11 of list 2. Items 63 to 66 of list 1 are carved out of the subject of education, and in respect of these items, the power to legislate is vested exclusively in the Parliament. That power of the state to legislate in respect of education, including universities, must, to the extent to which it is entrusted to the Parliament, be deemed to be restricted. It was further observed that if a subject of legislation is covered by entry 63 to 66, even if it is otherwise falls within the larger field of education, including universities, as covered under entry 11 of list 2, the power to legislate on that subject must lie only with the Parliament. Acknowledging that entry 11 of list 2 and entry 66 of list 1 undoubtedly overlap, it was held that these entries must be harmoniously construed and to the extent of overlapping, the power conferred by entry 66 of list 1 must prevail over the power of the state under entry 11 of list 2. The majority of the bench concluded that power having regarded to the width of those items must be deemed to vest with the union. Power to legislate in respect of medium of instructions insofar as it has direct bearing and impact upon the legislative head of coordination and determination of standard in institutions of higher education or research and scientific and technical institutions must be deemed by virtue of entry 66 of list 1 to be vested with the union. This court rejected the argument that prescribing the medium of instruction is not a matter falling within the determination and coordination of standard of higher education of entry 66 of list 1. it held expressly that it is within the purview of the said entry. Accordingly, it was held that the state legislature was not competent to legislate in that behalf. This is the contra view at that point of time. Then subsequent view was also contra, that 1995 State of Tamil Nadu versus Adhiniyam Educational. I am skipping also this one also. Now coming to Roman 3. From here, the law has changed. Priti Srivastava. In Priti Srivastava versus so-and-so, this court considered the question whether it was open to the court, open to the state to prescribe different admission criteria in the sense of prescribing different minimum qualifying marks for special category candidates seeking admission to the postgraduate medical courses under the reserve category as compared to the general category. This court observed that both the union as well as the state have the power to legislate on education, including medical education, subject inter alia that to entry 66 of list 1, which deals with laying down standard of institutions for higher education or research and science and technical institutions, as also coordination of such standard. A state has therefore the right to control education, including medical education, so long as the field is not occupied by any union legislation. It was further observed that the state cannot, while controlling education in the state, impinge on standards in institutions for higher education because that is exclusively within the purview of the union government. Therefore, while prescribing the criteria for admission to the institutions for higher educations, including higher medical education, the state cannot adversely affect the standard laid down by the Union of India under entry 66 of list 1. This is the change. Legislation is permissible, but it cannot dilute the criteria. So this is the change from where the law has gradually changed till last year also, Lordship. The whole process during this course has followed this principle. Earlier, if the field is already occupied by the central government, the state cannot enter also. Here at least say that state can also enter, but the standard set by the central government cannot be diluted. That since norms of admission can have a direct impact on the standard of education, only such norms or rules may be prescribed which are consistent with or do not affect adversely the standard of education prescribed by the union in exercise of the power under entry 66 of list 1. By way of, I'm skipping this because I have read this all yesterday. Coming to next, Roman 4, Modern Dental College.
These are the judgments.
Lordship, on the basis of these judgments, some opinions has been formed because today they wanted to change it, the other side. So I am clarifying it now. In Modern Dental College versus so-and-so, this court was called upon to adjudicate upon the challenge of the virus of Niji so-and-so Act Adhiniyam 2007, read with the Madhya Pradesh Private Medical and Dental Postgraduate Entrance Examination Rules 2009. The said act and rules were framed primarily to regulate the admission of students in postgraduate courses in private professional educational institutions and also contain provisions for fixation of fees and reservation of seats in such colleges. A challenge was laid by the appellant therein, which were unaided private medical and dental colleges, to those provisions of the act and rules which ought to regulate admission, fixation of fees, reservation, eligibility criteria. The arguments raised by the appellant therein before this court were found inter alia on the power of the state to enact such a legislation. It was argued that the matter for admission in higher educational institution falls within the purview of entry 66 of list 1 to the 7th schedule of the Constitution, and it is not covered under entry 25 of list 3 of the 7th schedule. In that background, this court undertook an analysis of the scope and ambit of entry 66 of list 1 relative to entry 25 of list 3. This court held that entry 66 of list 1 is a specific entry having very specific and limited scope. The trend is now changing, Lordship, narrowing down the scope now. It deals with coordination and determination of the standard in institutions of higher education or research as well as scientific and technical institutions. Thus, when it comes to prescribing the standard for such institutions of higher learning, exclusive domain is given to the union. That such coordination and determination of standards insofar as medical education is concerned is achieved by the parliamentary legislation in the form of the Medical Council of India Act 1956 and by creating the statutory body like MCI. With reference to entry 25 of list 3, it was observed that regulating education as such, which includes medical education as well as universities, it is a matter under the concurrent list. That earlier education, including university education, was the subject matter of entry 11 of list 2. Thus, power to this extent was given to the state legislatures. However, this entry was omitted by the Constitution's 42nd Amendment Act 1976 with effect from 3rd July 1977. And at the same time, entry 25 of list 2 was amended. Education, including university education, was thus transferred to the concurrent list. And in the process, technical and medical education was also aided within the scope of entry 25 of list 2. With that preface, it was observed that the said case that on a harmonious reading of entry 66 of list 1 and entry 25 of list 3, it would become manifest that in matters concerning coordination and laying down of standards or
the central agency is required to lay down the minimum qualification and that can't be changed. In your cases that apart from that additional qualification, the state is free to do.
Lordship.
That is what.
So let me complete this judgment on it.
This judgment is,
No, this judgment regarding what this modern dental policy. Two small paragraphs, Lordship.
Yes.
I'll not go to complete the whole paragraph. If Lordship wants, I can continue tomorrow also. But because they are challenges state act and it's a serious business for us. I do not want to leave any stone unturned. I'll place everything.
You are.
In fact, I wanted to.
That you have already.
No, because how the law has changed. That is why, Lordship. The law is gradually changing. Earlier, it was total bar. Then, to some extent, now limitation is given to the central government. Now the state has more power. This is the transition. That transitional thing which I am trying to emphasize before this honorable. With that preface, it was observed that the said case that on the harmonious reading of entry 66 of list 1 and entry 25 of list 3, it would become manifest that in matters concerning coordination and laying down of standards in higher education or research or scientific and technical institution, power rests with the union parliament to the exclusion of the state legislatures. However, insofar as other facets of education, including technical, medical education, as well as governance of universities are concerned, even the state legislatures are vested with powers by virtue of entry 25 of list 3 of the 7th schedule of the Constitution. That the field covered by entry 25 of list 3 is wide enough and as circumscribed by the limited extent to it being subject to entries 63, 64, 65, and 66 of list 1. All these 4 entries do not cover the education and the present subject matter here, Lordship. It was observed that most educational activities, including admission, have 2 aspects. The first of such aspect being the adoption and settling the minimum standard of education. That was essentially to lay down a uniform minimum standard, not maximum. Here also, uniform minimum standard for the nation with a view to provide a benchmark quality of education being imparted by various educational institutions across the country. To this end, entry 66 of list 1 was formulated with the objective of maintaining uniform standard of education in fields of research, higher education, and technical education. This court went on to observe that the second aspect of the regulation of education is with regard to the implementation of the standard of education determined by Parliament and the regulation of complete activities of education. These activities necessarily entails the interest application of the standards determined by Parliament in all educational institutions in accordance with the local and regional needs. Here, we are concerned about this, Lordship. If our schools are suffering because the students are not getting a properly qualified teacher at the level of graduation and the different stream at the post-graduation, that is the problem we are facing. That is why this amendment has come. Therefore, it was held that while entry 66 of list 1 dealt with determination and coordination of standards, On the other hand, the original entry 11 of list 2 granted the state the exclusive power to legislate with respect to all other aspects of education, except the determination of minimum standard and coordination, which was in national interest. Subsequently, via constitutional 42nd amendment, the exclusive legislative field of the state legislature with regard to education was removed and deleted, and the same was replaced by amending entry 25 of list 3, granting concurrent power to both the parliament and the state legislature, the power to legislate with respect to all other aspects of education, except that which are specifically covered by 63 to 66, so and so. So I'm skipping lordship all this. Then I'm just giving a reference 132, 133, 134, 148, 149. 149, may I read it, lordship?
Yes.
I have no hesitation in upholding the virus of the impugned legislation, which empowers the state governments to regulate admission process in institutions imparting higher education within the state. In fact, the state being responsible for welfare and development of the people of the state ought to take necessary steps for welfare of its student community. The field of higher education being one such field, which directly affects the growth and development of the state, it becomes prerogative of the state to take such steps which further the welfare of the people and in particular pursuing higher education. In fact, the state government should be the sole entity to lay down the procedure of admission, fees, etc., governing the institution running in that particular state, except the centrally funded institutions like IIT, NIT, etc., because no one can be a better judge of the requirement and inequalities, inopportunities of the people of a particular state than that state itself. Only the state legislature can create equal level playing field for the students which are coming out from the state board and other streams. So basically, and last portion also is there. It will be difficult because there is no paragraph number. So now, two thousand 2001 8 SCC page 661. 2001 8 SCC 8. In Aussie, we said one fat lady. Page lordship 66664. 664, paragraph 9. Because my learned senior friend wanted to explain Priti Srivastava, what the Supreme Court has explained Priti Srivastava, paragraph 9. A 5-judge bench of this court in Dr. Priti Srivastava made an exhaustive consideration of the scope of entry 25 of list 3 in the 7th schedule of the Constitution and entry 66 of list 1 in the 7th schedule of the Constitution. This court made it clear that the state's competence under entry 3, list 3 entry 25 to control or regulate higher education is subject to the standards so laid down by the Union of India, and states have competence to prescribe rules for admission to postgraduate medical courses so long as they are not inconsistent with or do not adversely affect the standard laid down by the Union of India or its delegate, fixing minimum qualification marks for passing the entrance test for admission to postgraduate courses in concern with the standard of postgraduate medical education. Once minimum standards are laid down, the states are competent to prescribe any further qualification for selecting better students, as they would not adversely affect the standards so laid down by the Medical Council of India. So this is what I am trying to emphasize on the PTC Bastata. it has been further explained in this case. Now, one judgment, 1994, 4 SCC. 1994.
Proposition है तो why to
No, this is in service matter. Now I'm coming back to service matter.
same judgments on the same subject.
1994 4 SCC. There are some differences, otherwise I would not have repeated all this. In 1994 4 SCC page 391, paragraph 7. Paragraph 7, I'm not reading the whole. Placitum D, the governor. In the So this is relating to service method of the governor has got Placitum D just along with on the right hand side, page 396. The governor has been given power under proviso to Article 309 of the Constitution, subject to any law made by the state legislature, to make rules regulating the recruitment, which include prescription of qualification for appointment to an office or post under the state. Pausing here, our rule is also under 309. Since the Transport Department under the Act is constituted by the state government and the officers appointed to those posts belong to the state service, while appointing its own officers, the state government as a necessary adjunct is entitled to prescribe qualifications for recruitment or conditions of service. But while so prescribing, the state government may accept the qualification or prescribe higher qualification, but in no case prescribe any qualification less than the qualification prescribed by the central government under section so and so of section 203 of the Act. So this is a direct case in our favor. That whatever the central government is prescribing, we cannot dilute while giving the prescription. We can enhance the qualification while making a rule under 309. And this law has been supported this year of 1994, but a recent judgment of 2023, very 28 November 2023, in the case of Jaivir Singh and others versus state of Uttarakhand, reported in 2023 SCC online. SCC online, Supreme Court 11584.
Yes.
Paragraph 52. Assuming for a moment that the 18 months DLA diploma by NIOS to ODL mode is equivalent to the 2 years diploma in elementary education recognized under the notification of NCT dated 23rd August 2010 and 29 July 2011. The next question that has to be answered is, can the state be prohibited from prescribing the minimum qualification which is higher than that? That means NCA has prescribed something, whether state can give a prescription beyond what is given by the NCT. a similar question arose in consideration in Satyapal Reddy versus so and so,
Which you have referred.
which I have just referred. That is why that law is still followed. And I would like to also place next page, paragraph 25.
Yes.
One short paragraph. In Jarur Ahmed versus so and so, have lots of it, paragraph 25. In Jarur Ahmed Rathar versus State Imtiaz Ahmed 2019 QSCC 404, it was held that the state as an employer is entitled to prescribe qualifications as a condition of eligibility after taking into consideration the nature of the job, the aptitude required for efficient discharge of duties, functionalities of various qualifications, course contents leading up to the acquisition of various qualifications, etc. Judicial review can neither expand the ambit of the prescribed qualification nor decide the equivalence of the prescribed qualification with any other given qualification. Equivalence of the qualification is a matter for the state as recruiting authority to determine. So my humble submission is that having regard to the above, in our view, the High Court has erred in so the principle is laid down in paragraph 25. So while we are allowing certain subjects of the postgraduate level, the expert opinion was taken. And regarding the graduation level, we want the same stream. We have a reason which we have elaborated in our affidavit, maybe not with a proper affidavit, but in our affidavit in opposition, we have stated that. Whether state can do that or not.
Yes.
Lordship, in our affidavit, we have elaborated the reason. And therefore, there is no response to that. There is no counter. Either through an affidavit in reply or through any other submissions. So they are not disputing the opinion given by the bodies which have advised the state government to go for the necessary.
They are essentially questioning the
power
of the state government.
the competence of the state government.
But
Regarding the essential qualification, I am not reading out, just giving the reference, 2019 6.
Which one?
Another one. The proposition regarding the qualifications required for our employees. And the last one, which
multiplicity of
no, I'm not, Lordship, there are differences. Anyway, I'm not being able to properly address this honorable court. But the thing is that there are differences which they are trying to highlight. Lordship has already said, I'm sure Lordship has understood what I am trying to explain. But I am still not happy, satisfied with my.
Plain and simple case is their case.
It's a very simple case, Lordship. In fact, my
Plain and simple. Their challenge is that since this qualification is not there in the NCET, you can't introduce it. This is what case is.
In fact, my learned friend was correct in one where I agree that it is an open and shut case. That I agree. But to open and shut it, we have to pass through 2 days argument.
This open and shut case for both of you, because now you have concluded the arguments and now
Now it is open for.
So it is open and shut case for you people, but not for us.
That Lordship, that Rajasthan's case with my learned friend, Rajasthan's case, they have read paragraph 79. That what is higher qualification? They have actually left out paragraph 63, where the higher age qualification, which was considered by the Rajasthan government Lordship, it was actually not a higher education qualification. It was a separate qualification. That is why the Supreme Court passed that order. So that is a distinguishing factor, and that is why it is not applicable in the instant case. Highly obliged, Lordship.
Order is up.
Deeply obliged.
ओहो ये तो आपने आज बताया
My lord.
तो आपसे we are deprived of your argument, sir. Oh, thank you very much.
My lord, in respect of item number 37, my lord, may I pray for matter may be taken up tomorrow, my lord, if I'm not inconvenient.
Tomorrow?
Yes, my lord. I'm for the respondent numbers of board.
Tomorrow is not for,
No,
please,
no, no.
try to understand. Next week, anything.
Lord.
There's an interim order in 37, Lordship, that matter.
Let it come on Monday, Lordship. I am for the pollution control voting that.
Monday, Lord.
Monday.
Monday, Tuesday, Tuesday, Tuesday.
Tuesday, Lord.
Wednesday.
Lord, safely of that.